been masking.
Good evening, everybody. Guys, please stand and salute the flag. It's behind you. Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. As per requirement, the notice is hereby given. This is a regular meeting of the Borough of Highlands Land Use Board, and all requirements have been met. Notice has been transmitted to the Asbury Park Press and the Two River Times. Notice has been posted to the public bulletin board. Formal action will be taken. Roll call, please.
Mayor Brion.
Here.
Chief Burton.
Here.
Mr. Kutash.
Here.
Ms. Larissa.
Here.
Sugar. Hold on.
That's my nickname.
Sorry. I should know all your names by heart by now. Ms. Chang.
Yeah, I'm here.
Ms. Larissa. Yes. Chair member of Shevsky. Here. Council member of Shevsky.
You want us to say our names?
Yes, please.
All right. Chief, why don't you start it off?
I think the mayor's first, right?
Yes.
Mayor Brion, here.
Chief Burton here.
Kevin Cody here.
Mark Dill here.
Dean Kramer here.
Bruce Kutash here.
Lori LaRussa here. Joanne Olszewski here.
Emery Tierney here.
Rob Knox here.
Ann Peterson here. Alan Chang here.
We have a quorum.
Okay. All right, thank you. This time, this is open for general questions or comments on the proceedings of the evening. Nothing to do with tonight's case, just on how we operate at the land use board level. Any questions? Okay.
Yes. I'm not clear on which members are actually voting on this.
We'll get to that. Yeah, we'll get to that. We have a couple cases tonight, so some will recuse themselves, others will come back and stay. So we'll see how it goes, but that'll be
So
maybe.
let us know before we...
Absolutely. Yep. Okay. You, sir? I think this requires 5 out of 7, I believe, for tonight's application. But again, this is not the application. This is the general proceedings of our hearing. Has nothing to do with any applications at this point. Just our order of business.
Well, I think this is along the same line. Why are so many people recusing themselves?
In general, when you see people recuse themselves, they're typically within conflict of the business or property in question. They're within that 200 square foot radius. They've never been noticed on something in town, not necessarily the application, but another zoning application. Then the members of the board would recuse themselves as a conflict of interest.
Also, for when an application involves a D variance, the mayor and council person cannot sit on those applications, so they never participate. When the land use board is acting as a zoning board of adjustment for a D variance, the elected officials can't participate, so they recuse on those.
Okay. Anybody else have any questions on the proceedings? Not our case tonight, just on how we do things. Okay, seeing none, thank you. All right, at that point, hearing on old business, conditional use, LUB 2022-011, Seagrass. I do see the council here this evening.
Good evening. John Anderson on behalf of the applicant Seagrass, NJLLC, and James Whalen. I believe when we left off, we were at the public comment section of the presentation. I had concluded my direct, the objector had concluded his direct. To echo the point raised by the public, I just want to quickly go over the 7 members that would be voting on this application, make sure that they've all attended the prior hearings and that where they were absent, they've certified that they've listened to the tapes. I'll read the members that I think are eligible, and if you just correct me if I make a misstatement. I have Chief Burton as eligible, and he had certified to listening to the tapes of the 3rd hearing. I have Chair Knox as eligible, having certified to listening to the tapes of the 2nd hearing. Mr. Kutash, Ms. LaRussa, Ms. Tierney, Mr. Zill. I think I have both strike that. Mr. Kramer was absent last time.
And I sent the letter certifying that I...
Okay. And Ms. Peterson was at all the hearings. Seeing that there's 8 eligible members, I just want to make sure which of the alternates would be voting on this particular application, so I know who my 7 are.
I also certify that you do all videos.
So we actually have, what, 9?
Yes.
And Ms. Chang, I had you absent at the first, second, and third hearings. I'd be certified to all of them?
So we're doing it by alternate number
Well, I would,
rather than attendance?
No,
the attendance is fine for those that we just mentioned.
Right.
It would be the full-time members first, and then if,
Among the alternates, is it the number of alternates?
It
So Ms.
usually
Chang
go-
is number 1.
usually go alternate 1, then 2, then 3.
Okay.
So,
Okay.
so which alternates are voting tonight?
So Ms. Chang is alternate 1, Mr. Kramer's number 2, and Mr. Cody is number 3. So
okay, I'm not
those
sure
are-
Mr. Cody has
and
listened to
then-
all the tapes.
Right, and then Dr. Peterson is the 4th alternate, and she has been here the entire time.
Okay, okay. Well, that clears up for you, council.
So the eligible regulars, and then I guess Ms. Chang. Correct?
Yes.
Okay,
Thanks.
thanks. I'd cede the mic to the public to continue their comment, not questions.
Okay.
The only thing I'd ask of the board is that we had quite a few people that got up and speak last time, and they entered their comments, and if they've already spoken, just in fairness to the applicant, now having gone 5 months, I'd ask that they be prohibited from raising further issues if they spoke at the last meeting.
Okay, I guess we do have several members of the board here that have to recuse themselves for this part, at least. Okay, so we might as well go ahead and do that, I suppose. So I know the gentleman had a question on who was staying and who was going.
There is a subdivision application.
Yes, we'll be back.
Okay.
We're just gonna go, I'm gonna go look at the procedure.
Very good.
Okay,
All right.
so I officially recuse?
Yes.
We also,
Okay, where we did leave off last time, it was both the applicant and the defendants had rested their case. We had heard from people of the audience. We had gone through the question period. We're now into the comment or like a statement period. That's where we're at. So after we hear from you folks, we'll, I guess, go back to the board. And at that point, we'll either, we'll decide on what we're going to do the rest of the evening. So that note, anybody from the audience have anything they want to add to this application? Any comments or statements?
If you do, please go up to the microphone, introduce yourself, and give us your comment.
Okay, somebody behind you first, but yep. Oh, go ahead. Yep. Yeah, just state your name and address, please.
Melissa Peterson, 17 Bay Street. I guess my comments being that based on the fact that the parking lot is across the street and their traffic study indicated they didn't take into effect bicycle traffic, pedestrian traffic, traffic not specific to Highlands, and the amount of traffic we get in the summertime, the amount of traffic we have all year round with the commuter traffic, the fact that the amount of people that have been hit by cars on Bay Avenue. I mean, Leo's wife was hit right in front of Chilango's just trying to cross the street by an electric bicycle. And I understand that the council voted that you can have them across the street, but my understanding is they don't meet the requirements because of the footage away from on Seadrift side, so it's up to you to kind of make that decision on whether they qualify or not qualify. And I think public safety and the amount of people that have come here for the past 6 months, your neighbors, other residents, some of the people are your friends, some of them aren't, but they came for the last 6 months, every single meeting or tried to. So I hope you guys take that into consideration. It's also disheartening that was quite obvious that some of you already made up your minds before the testimony was even given. And I mean, Ms. Cherney, I mean, you moved next to a restaurant that became a nightclub. And you should understand the residents on Seadrift that move next to a restaurant. And, no, Miss Tierney.
Are you suggesting that you think I expressed an opinion before tonight? Because I would challenge that assumption, but.
Okay, well, let's just keep it simple. Let's get into any
It's not a
accusations.
question, and it's just, I'm trying to get you to relate to the fact that you should be able to empathize with residents because you were under the same situation, and unfortunately it didn't go in your favor, but I'm hoping that you have empathy for the neighbors on Seadrift. That's it.
Thank you. Anybody else? Okay.
Justin Mealy, 26 Seadrift. I guess my only point that I really want to make is I think everybody here understands that what we're not trying to decide here is the legality of selling marijuana within the town, whether it's permitted. I think everyone understands that. I think what you've probably heard over the last 5 months from people is it's really a volume issue. If you really look at any of these other places that have it, you know, Neptune's a good example where I think that town itself struggled for months whether to open it up to recreational use due to that being able to handle the volume. If that's something that was in basically a shopping center area, massive parking lot, highway, I think it's like 3 or 4 lanes, and they actually didn't think they could handle the volume there. So the town went back and forth on that for months. You're dealing with Highlands, a much smaller town, single lane roads. There's not enough parking on any of these streets, even for the residents to do it. If you actually look at the lots of a lot of the houses, they can barely fit 1 car in their driveway. Some of them don't even have room in their garages. There's just no room. Like, it's something that you see every day. You just drive on the streets. It's condensed. I mean, you can't even have 2 cars driving on Seadrift in itself at the same time. Cars have to pull over to let one go. You just see the volume that these kind of shops like bring in. Nobody's questioning whether it should be allowed at all. It's the location that doesn't make sense. It's a residential area. I understand that it's zoned for being commercial use. It's not a commercial area. There's a pizzeria, a laundromat, a liquor store. That's about it. What shopping are these people going to do when they're walking around? I understand there's a grand plan for development of the area. That makes sense. It's not there yet. You're just going to be sending volumes of people onto the sidewalks in front of people's houses, cars parking, blocking driveways. It's the studies that were done to sit there and justify that this isn't going to be a problem. There were reports that were done somewhere in the U.S. Nobody knows the data points. It's about 3, 4, 5 of them. From what time period? Nobody knows what the towns look like. To me, it's absurd to apply that to our town in itself. Just walk along the streets. I know the mayor just said she's going to the street itself. Look at it. It's clear. It's very obvious that it can't handle it. There's other areas in town, and it seems like one was already approved for a different area that makes a lot more sense, a more commercial area, not as many houses in the area. Would I approve of it if I was in that area? No. I'd probably still be up here saying, I don't want that volume by me. It's not the product. It's strictly the business of what it brings in. It's a volume game. We can't handle it in that area. It's just, even Chilangos at times, is really frustrating with all the people on the sidewalks, forces you to walk in the streets a lot of times. The parking lot is not adequate to actually hold it. I understand that there only needs to be 2 parking spots, but it's not for that business. It's a general rule that you have for most businesses, but this isn't most businesses. We've heard that there's a whole set of new regulations, rules that go along with those kind of businesses. Armed guards. Think about that. What are we going to have? Armed guards standing outside? There's no other businesses in town that has that. The bank doesn't even have that. It's just absurd. You have all these things, security cameras. We've heard how this single security guard is going to be in charge of traffic control, safety, watching the vaults, watching the parking lot across the street. One guy. I don't know how much they're paying this guy, but it sounds like it's going to be the best law enforcement person you've ever seen. To me, this is just all absurd. It's a location problem. That's it. Nobody's debating whether it's marijuana, whether you should have it or not, medical use of it, recreational use of it. I don't think anybody in here really cares. I think you heard most people in here say they actually use it. But go to any of these places, it just creates problems. I think you just have to think about, it says on the application, are there any negative effects to the community? I think you have a room full of people here who live in the community who are saying, yes, there will be a negative effect to them. Then all you're doing is taking an expert who hasn't, if you actually read the report, it was Google images searches and reports done from somewhere in the U.S. that nobody knew the data points for, what kind of towns they are, to justify saying, yes, this town can handle it. But you have people who live here, who live in the community. To me, I just don't understand the role of all this. You have people in the community who pay taxes, who just want to live in quiet enjoyment of their houses. this is being impacted by this business. I think it's that simple. To me, it's just, I don't understand, like, why are we fighting the will of the people in the community? As you have everybody here saying it will have a negative effect on them. You're debating whether it's an arbitrary 1,000 feet from a school, and we're sitting here saying, well, 50 feet, which ironically I think is about the size of 2 school buses, is the difference of whether that's allowed or not, with a parking lot that is inside of it, the building outside of it, and we're like, well, technically you don't know if people are going to be really bringing marijuana into the parking lot, smoking it, what they're doing with it. It's just, to me, it's all absurd. I just don't understand how we're fighting with all the people here. We had a counsel for the applicant sitting here fighting with everybody in the town, treating them quite rudely during the whole entire process. I just don't understand, like, why this community wants to be used this way. I don't get it. It's just something to me I just don't understand. I know you guys are going to vote on this, and I know there's going to be a strict set of rules so you have to vote on it, but if you really think about it, a lot of the stuff that they're asking for variances on with the property, it matters to this. It sits on basically, what is it, like, what did we decide? It was like 99.8% of, like, the property, something like that. Like, we're talking about painting it. The outside of it is going to be what's going to make the neighborhood so much better. We're, like, sitting here debating, like, oranges and blues and saying, well, we're going to change the awnings on it. Like, I don't understand how that makes the neighborhood better if you're just dropping thousands of people onto these streets. It's just absurd to me. That's basically all I have to say. Thank you.
Sir.
Firstly, I would like to thank this board for their great sacrifice of their time away from their families to serve our community. This is what I would call a kind of like a thankless job. It takes away a lot of your personal life for the benefit of all the people in this room and in this town. And I don't think a lot of people really realize this, that, you know, this takes a lot out of a person to do this on a regular basis. So thank you very much. Secondly...
Name and address, please.
Oh, I'm sorry. My name is Arthur.
Objector's counsel, should he be saving his summation for the end after I've made my summation?
Well, you're going to give the last summation. Your last.
Speaking as a neighbor.
Yeah.
May I proceed?
Please.
I would also like to call out counsel, because I think that you may not know this, but you have one heck of a good attorney, and the former attorney, in my opinion, yes, I'm talking about you, and your partner, in my opinion, are both excellent. Now, I don't, as you know, this is not my field, and if I shouldn't go any further, you tell me and I'll stop. I just want you to know that I'm going to speak freely, and I'm not going to speak law. But there's a few things that are on my mind that I would like to share with you. And if counsel objects and he doesn't want me to speak at this time, he wants me to speak 10 minutes from now, that's fine. First thing I want to bring out is just some shorts. As attorneys, we know that we have to get started someplace. So what happens is, when a challenge is made as to jurisdiction, the attorney has to size up whether or not what's called prima facie case, which is just enough to get your foot in the door, so to speak, has been presented. And I think that even the issue here as to the initial opinion of counsel, of board counsel, that was raised several times, was not as the audience perceived it. They don't understand that as attorneys, we don't go by photographs, we have a moving picture. So what may be our opinion to this moment may change 2, 3, 4 meetings from now, etc., as the case is developed. I think that covers the initial thing as to the jurisdiction, the question that arose on that first evening. The second thing I would like to talk about, and these are just shorts, is witnesses versus argument. Experts like Mr. Streck, like Mr. Klein, they are fact witnesses. They are able to give expert testimony. Attorneys don't testify, and what we say is in the category of argument. That is different. Whatever an attorney says, me or my esteemed colleague, that is not a fact, and that is not a witness. We're just arguing for our clients, or in my case, myself. So you have to think, every time you were told something, was that actually a fact witness, or was that just legal argument? And it's easy to, when you're going back and forth really fast, to have that line blurred. Third, I would like to discuss momentarily the doctrine of hearsay. Hearsay is when somebody who is not here has written or said something, and another person who didn't say it or write it says what that person who authored it said. So, for example, I'm holding up here an article which I distributed, and it's entitled, "Do Marijuana Dispensaries Increase Neighborhood Crime?" As you know, I gave this out, but I did not use it. And it was written by an esteemed Dr. Lorraine Hughes, a professor at the University of Colorado. The reason why is because Dr. Hughes is not here to testify. I cannot put Mr. Steck on and say, tell us about what Dr. Hughes says about this issue of crime, because that would be hearsay. The person who wrote it has to be here to explain and answer questions to your satisfaction. So what struck me immediately, and I think we even had a short colloquy in the very beginning when I started, was Mr. Klein, who testified based upon the studies that were done on the issue of dispensaries by the engineering group ITE. Those engineers are random engineers throughout the country, and they do a study in their local neighborhood, and that is what they report to this body called ITE. Now, the reason why that study or those studies are hearsay is because they're not here to testify. For example, I asked a question, and my question was on seasonal traffic. And I said, do you know whether or not any of these studies took into account seasonal traffic? Because we have seasonal traffic. As you know, living here, the traffic could change to gridlock in a matter of minutes. So the answer I got was, they have resorts in California. Well, hold up a second. Now, the person who wrote those reports in California are not here to testify. Secondly, one of the questions, if they were here, would be, where was this study done? Was it done in Manhattan Beach? Was it done in Fresno, California? Big difference. Because if you're in Fresno, the population density and the amount of traffic is going to vary differently than Manhattan Beach in the summer. If you've ever been to Manhattan Beach or Muscle Beach, you know what I'm talking about. Big difference. Same thing with here. In the wintertime, it's relatively quiet, but in the summertime, you could have gridlock, and we have had gridlock in this town. I remember 2 years ago, it took me about an hour and a half to get from Rumson Road over here to my house. So this is a major factor. When I said, what are we going to do if 500 cars show up? I mean, maybe it may not happen, but what would we do? I think, as my neighbor said, we can't handle the density of the traffic that we have now. And I know that there's another applicant that's coming before your board, and they're going to ask for permission to build 4 houses the next block from me, and I'm not going to oppose that, but that's probably 8 more cars on our street. I mean, we're going to have to put these garages up where you stack the cars up. We literally are that jammed up on our street. So those are the 3 kind of like shorts I wanted to discuss. And then generally I want to make some points. You know, as a former criminal law judge and as a criminal law attorney, I think a little bit differently than most folks. I have to tell you, I think more aligned the way the chief thinks. And I know this because I've worked with local police, county police, state police, FBI, and I could tell you that when I hear of businesses such as this, I automatically think, what is going to be the cause and effect? What is going to be the Newton's third law? For every action, there's an equal and opposite reaction. So, I just found out last week that there was a burglary in the dispensary over in Eatontown, as you probably read in the newspaper. It came early in the morning. Do they have cameras? I guess so. Did they think they were going to? No. They haven't caught the person yet. It's not the police fault, but this is cause and effect. Secondly, and this is what really worries me, is the children. We have a lot of children in our neighborhood. I don't know if you realize that or not. And a lot of them get off the bus and get on the bus right there. Now, this came up casually during the course of this meeting with the traffic engineer, and it was said that the security guard would assist or help the children cross the street. I say no. He's not legally obligated to, and secondly, he could be legally liable if something happens. That will not be any assurance that those kids will be able to get off and on those school buses safely. But even worse than that is what I'm about to tell you, and I don't mean to scare you, but it is a little scary. You may have read there was a luring 11-year-old girl in Asbury Park. It was in the paper. Chief probably knows about it. And they arrested the guy for luring. Now, we all know that if you're talking about alcohol, how many times do adults say, okay, I'll buy you a six-pack of beer, give me $25. Okay, here's $25, and they give it to a 16-year-old, right? I can envision, especially with gummies, hey, little boy, hey, little girl, you want a piece of candy? Or maybe 16, 15, 17-year-old saying, hey, here's $50, go buy me a dozen gummies. Don't you think that's going to happen? As sure as I'm standing here tonight, I'm telling you that's going to happen. And that really worries me. You are inviting what I call an attractive nuisance into the town, and nothing against this applicant, it's not at all. If it were somewhere else, like on the highway, different story. But this is 3 commercial lots in the middle of 24 round-the-clock residential. All around these 3 commercial, just 3 lots. And all around it is residential. We are scared. Now, you say this can't happen, it won't happen. April 1st, 2023, 11 p.m., I'm in bed asleep where I should be. Highlands Police Department. I come downstairs, officer, what's going on? Your car was hit and the driver ran. I'll give you one guess where that car came from. Anybody guess? Shalengos. Okay? The driver, well, I don't know if he worked there or he was a guest there. He got in his white car, and I got to tip my hat to Chief Burton and the Highlands Police. They said, we're out looking for him. They caught the guy within an hour. I never thought that. I figured he's up on the highway, he's out of here, he's gone. They got the guy. Okay, they charged him with several motor vehicle offenses. Okay, cause and effect, Newton's third degree. Third law, what happens? You are putting stuff into the stream of commerce, and this is going to be the ripple effects. You're going to have these issues come up. I don't know whether or not everybody thinks about this stuff, but I think about it, and it worries me. It also worries me that when I bought my house, I was God bless you. I was expecting a certain type of peace and quiet enjoyment of my home. I wasn't expecting that I'm going to have to fight for a parking spot or picking up litter. And I know that you may not realize this, but even if we have some type of affair like we do every summer, we get problems from that. 2 years ago, someone threw a glass bottle against my house and shattered glass all over the place. No one knows who did it, okay? But this is the kind of thing when you're bringing in people, they're not from our area, they don't have any ties to the community, they're not going to present themselves and act in accordance with the same way that we residents do. So, for these reasons, and for many others, especially, I think you can say beyond any reasonable doubt, that the community at large is opposed to this. So if, I'm not going to say what to do, that's up to you, you're independent-minded people, you think for yourselves, which is what America's all about. But I could tell you that your neighbors are not for this. Not because they have anything against marijuana. It's just the wrong place. It has nothing to do with the applicant or the business. It's just the wrong site. And so, and one thing that I want to just mention that Peter mentioned is that he felt that there was nothing, no evidence presented by the applicant as to the deficiency being 994 feet rather than 1,000 feet away from the school. That's what he impressed upon me. With that, I'm going to say thank you very much. I appreciate your courtesies, and I have to be in court tomorrow at 9, so I'm going to excuse myself, but thank you. I appreciate it.
Anybody else? Could you just state your name and address, please?
Certainly. My name is Maggie Zeke. I own 213 Marita Bay Drive in the Highlands. I did want to talk about the elephant in the room, about the large amount of cash and weed that was robbed from the Eatontown store. Now, currently, these facilities are not allowed to deposit the cash in the bank, which makes it a target for people to come in and rob these stores. And it's something that you really need to think about, because you are inviting these people in, and it might not just be the one guy that steals, it's going to be the next guy and the guy after that. And I know that from experience. So I really want you to take into consider who you're inviting into this neighborhood. You know, think about the kids and how it's going to affect them. How are they going to look at these dispensaries when they see, you know, adults going in there saying, you know, this is okay? But it's not, because you're affecting their mind, and you really have to take that into consideration. Speaking of the lines, the line isn't just going to be in front of Chilango's, it's going to be down the block. Because if you go and you sit in front of that dispensary in Eatontown, that line is around the building. So it's not going to just affect in front of Chilango's. It's going to affect houses, residents, streets. People are going to be waiting in the street next to Chilango in line just to get in there. So it's really important that you know that. Also, I want to state a fact here that one out of 2 dispensaries are robbed. 1 out of 2. Now, currently, we are number 14 in how many dispensaries we have here in New Jersey. New York is number 1. What state has the biggest drug problem and homeless problem? California. California is number one, not New York. Sorry. California is number one. So you have to take all this into consideration. What are we inviting into this area? People who get high, now they're a little tired. Now they're going to be sleeping on the beach. Okay? They're going to be sleeping in your backyard. You know, they're going to be sleeping in my driveway. You know, they're going to be defecating all over the place like they're not doing it already, but it's going to get worse. If you look at the area that Eatontown put their dispensary in, they didn't put it into a neighborhood. This is a neighborhood. People ride their bikes, you know? We have to take control of this and not allow our children to see it. Let them make that choice later on in life as adults, but it doesn't need to be in our neighborhood. So, thank you very much for your time and for listening. Please, you know, think about our kids, okay, and what you're inviting in. Thank you.
Okay, anybody else from the audience? Okay, sir. Okay, just state your name and address, please.
Sal Albanese, 85 Seadrift Avenue. Just a couple of points. When the town changed the zoning on Bay Avenue, they didn't think that through. Bay Avenue is not all the same. The other end of Bay Avenue is commercial. Where we are is all residential. So that needs to be taken into account. So let's not compound that mistake by you guys allowing this business in there. Our taxes have gone up every year for the last 5 years. Every year our taxes are going up. Now we're going to do something that's going to make our property values go down. I'm getting ready to retire soon. How am I going to sell my house? I'm across the street from a weed dispensary. Who's going to want to buy my house? No one. Also, no one has mentioned the town council voted to approve weed. Leo, the owner of Chilangos, is on the town council. A little bit of a conflict of interest there. No one has mentioned that. The other last point, weed was approved in this town. Most of the other towns got the vote. We didn't get the vote. The town approved it without resident vote, which I don't think was right. That's all I got. Thank you.
Anybody else? Okay. Yeah, just state your name and address, please.
Yes, Tina Kemmer, 164 Linden Avenue. I don't have any notes, but I want to applaud all of the public, the residents here that have come up to speak on our behalf. And I want to acknowledge the fact that it's the residents here that matter. We're all concerned. I know the board members are also residents as well, but please keep in mind what, you know, how we feel. And I live up on Linden Avenue right across from the elementary school. It's not business as usual for us. It's business as usual for the business. So I really have to say that where Chilangos is situated, it's not optimal. It makes no sense. It's better maybe further down where Grimaldi's is in that area. Everything these folks have said, they're really speaking from the heart, as I am. You know, I'm not profiling what the board members, gee, have I got this guy in my pocket? Is this one? And this one in the audience looks a little, you know, like he doesn't like me. You know, that's what it's all about. It's a business. You know, we're the residents here that are really concerned. And I know I'm not supposed to ask questions, but what about like refurbishing one of those military things out in Sandy Hook and putting a pot dispensary out there? I mean, isn't that part of Highlands, or I'm not even sure. It's not. Okay, never mind. Maybe a great idea along the future, but please take our feelings, our concerns into consideration. I think everybody has a very valid point. So, and thank you for your time. I agree that, you know, you guys have a hard decision here, so thank you.
Okay, anybody else from the audience? Okay, yeah. If you would just please state your name and address.
I'm Kathleen Hands. I live at 201 Marina Drive, so I'm a block away from the property. I don't have a problem with having a dispensary in the business district. I just don't think that functionally this area, these couple of blocks, are a business district right now. It's a residential area, you're not playing off businesses next door that would have similar hours and can share clientele. This is residential property all around it. And maybe down the road sometime, it'll be a functional business district, but that section of town is not a business district right now, and it would be very disruptive to all of the people that live around there to have that kind of business there. Thank you.
Okay, if you could state your name and address, please, sir.
Sure. My name is Bob Fischler. I live at 20 Gravelly Point Road. I want to thank the board for the time to speak this evening. For the purpose of full disclosure, I am an attorney. I do practice in real estate, primarily in New York. I have been to every meeting regarding dispensaries that this town has had, or pretty much every meeting. I was not in favor of the ordinance to put a dispensary in this town for the reasons that former Councilwoman Mazzola set forth to the council at the time. It's been accepted, it's been approved, we're going to have a dispensary. So the question becomes at this point, what is the most responsible way for this town, and what's the best place to have that dispensary? I think there's only one. Oh, and I want to say one other thing. I have no horse in this game. I don't represent anybody that's involved here, any dispensary people. I'm doing no work in this town. So I'm here strictly as a resident. I built a house here 7 years ago. I would like to see this town improved. I have been very much in favor of most of the things that the council has done to look forward to improve this town. And this is one that I'm not particularly in favor of, but I think what we have to do is treat it responsibly. And that's why I'm here, and that's why I have spoken at these various meetings and have listened very closely to every application, every attorney, every expert that was put forward here. I'm perfectly cognizant of the limitations and the role of this board. I understand that you have very strict guidelines and parameters that you have to follow here, all right? And I think most people understand that also. If they've been to any of these meetings and they were listening closely, they would know that, all right? Now, to get into the actual application, if any of you recall, I forgot the first one, but I brought up an issue regarding collective bargaining and the ability that part of the collective bargaining could be having employees have on-site parking. That was routinely dismissed by both applicants and the board at one time. They said, well, this is too speculative. Okay, so it turns out it's really not so speculative. If on April 19th in the Asbury Park Press, there's an article, and it's about Curaleaf. Curaleaf is one of the largest dispensary companies, if not the largest, in the entire country. And they were denied a renewal of their permit. 4 days later, the Cannabis Commission came back and they said, okay, now we're going to reverse ourselves. And what did the Cannabis Commissioner say? That's the key. And I'm going to read this here. Commissioner Krista Nash initially voted against renewing Curaleaf's license, but on Monday, she said that the denial was a, quote, wake-up call, unquote, that reminded companies of labor requirements with the New Jersey marijuana legislation laws. Under those laws, cannabis companies must maintain a labor peace agreement, allow its employees to vote to unionize, and to reach a contract within 200 days. This is not such a speculative thing that we were initially discussing. And this is a public record. This is not hearsay because it's a public record. It's available by the public and available to this board. Now, I want to talk about a couple other things here that I heard from the applicant. The one thing that disturbed me, and this is a little bit because of my real estate background, was the argument made regarding having two separate pieces of property. And the statement was made, well, you know, when you have two separate pieces of property, they generally are owned by separate entities. That's not accurate. What you do when you have two separate pieces of property, you could have 5 pieces of property. What you form is what's called a single purpose entity. What's the reason for a single purpose entity? Well, you could have a shopping center and it's owned by a company. There could be 12 lots. There could be how many buildings and some pad sites. They're not owned each separately by separate companies. Why is it a single purpose entity? It's to protect a lender and the owner from liability. It's a liability issue. Now, with this particular application, the applicant stated, well, you know, we're going to do a lease, right? And if you recall the statement made by Mr. Steck, if you recalled listening closely to him, he mentioned something called a deed restriction. Now, these are two tremendously different things. A lease. Leases can be broken in many ways. I'll give you the most extreme example for the sake of argument. One of the companies files bankruptcy that has a lease. What do you think a bankruptcy court can do? They can cancel the lease. They can do all different kinds of things, and you have no control over it. Now, that's why a lease doesn't work. That's why you need a deed restriction. Can't do that with a deed restriction. Different issue. But when you have a deed restriction, you're linking the two pieces of property inexorably together. And this has to be done because you have parking across the street, right? Now, this whole parking issue and putting in a separate entity, well, this is parking and we can have a separate parking lot, doesn't work with the deed restriction. Doesn't really work because you're linking them now. And that's what you should be doing here. You should be a deed restriction, not a lease. A lease can be changed, can be voided. There's all different kinds of, I can go in forever to talk about leases because that's what I do for a living. I'm not going to spend all that time doing that. However, with a deed restriction, they're linked. Now you're linked. You have the building with the dispensary and you have the lot. The lot's within 1,000 feet of the school. That's why they have the separate entities and a lease, because they're trying to do whatever they can do to avoid the 1,000 feet restriction. I think that should be strictly adhered to in this particular circumstance. We have to be responsible here and be responsible as to how and where a dispensary is in this town. And for that reason, I honestly think, my humble opinion, is that this board should deny this particular application just on that basis alone. Thank you.
Anybody else from the audience want to add something?
Tough act to follow there. Yours as well.
All right, again, state your name and address, please.
Yes. Hi, everyone. My name is Blake Chesbrough. I don't live up the hill or down the street or around the corner. I live directly across the street from the front door. Chalongos is on one corner. I'm on the other. The parking lot's on the other. My driveway and garage, where I park my cars, are directly across the street from the entrance of Chalongos. So I attended most of the meetings for this. I missed the first one. So I'm clear, and I think everyone in this room, and of course the voting members and the council, understand that it's non-conforming. It just doesn't work. It's got 7 deviations. We understand by the applicant's attorney that in a lawsuit, some people were able to overcome those. This is 7 non-conforming deviations. everyone in the room is understanding that we're just short, but it's within 1,000 feet of a school distance. People keep saying, hey, the bus stop is nearby. The bus stop is nearby. I want to make it clear. The bus stop is the front door of Chilongos. That is where the bus stops, at the front door of Chilongos, which will now be the. So I know it's not maybe the legal thing, but let's face it, the bus stop is an extension of the school zone in a way, consciously, morally, maybe not in the letter of the law. But when that bus stops up, you hit the brakes, those are kids, you stop, and that's all taken care of. So when I recently retired or semi-retired, and I'm around the house a lot more. And I'm home during the afternoon now, which is wonderful. And I was outside watering my flowers today and my yard, and I counted, there's 5, 6, 7, there are 8 children that live, not that walk by, that live within eyesight of the front door of the proposed, drug place, or dispensary, pardon the terminology. So, I was standing there saying, and it goes to this gentleman in the front row here, it seems absurd. So I have no debate. I understand we're having a dispensary in town. But what I want to make a point is, my understanding is there are 3 applications. One application was approved, and in that area, you have a convenience store, a gas station across the street, a post office pretty nearby, not too far, and then multiple restaurants. Some are out of business; they're boarded up and need someone to come in there. So that area is a very business. You have behind it, you have the Department of Public Works, not my neighbor's house, Sal. Okay, so this end of the street, I think everyone's clear. This is kids, baby carriages, young couples all day long crossing the road there. This is a human story. The term ad nauseum was used many times, and I agree. We heard about, every incident and 2 feet here and 4 feet there and colors of this, and this is a human story. This isn't a story about a few feet or a few inches, other than the embarrassing thing that it will be within 1,000 feet of school zone. 8 children are within eyesight of that front door. So for me, we have like a cute little neighborhood. On social media in this town, you got to stay away. People gripe and complain endlessly. But also, people always say how they love this little town. It's like there's no other little towns like it anymore. A friend of mine was visiting on a very busy night last summer. We were sitting on my front porch, and they're like, this is so cool. This is almost like a little Key West-ish here. The same kind of vibe. People walking up and down the streets, going to the restaurants, the lines. I can pretty much, since I live on the corner, I'm on Seadrift, and many people have there is just no parking. I have to invite friends and neighbors to block my driveways on busy nights, Thursday, Friday, and Saturday nights in the summer, and I allow it. So anyway, it's a human story. So all day long, I happened to be home last Saturday, and I was shocked at the number of, I didn't know they changed the term. I want to say baby carriages, but they're now called strollers. Someone corrected me when I mentioned it. So it's just all young couples and people walking their dogs, saying hello. I happen to have a lot of flowering trees and shrubs in my yard right there across the street, so a lot of people stop and comment and chit-chat. And it's a community on this end of the town. It's a real vibe and a human issue. So I implore you voting members of this council, when we're all said and done here, to do the right thing. We have one application approved in a much more suitable environment of Bay Avenue. And also, it could invite people then to rent and open restaurants where they're closed up and boarded up currently. So I implore that. I understand we had another application that withdrew. So I implore this board to do the right thing, listen to the neighborhood, listen to your constituents basically, and vote no to this application. We will still have a dispensary in the other end of town. So 1 application approved, 1 application withdrawn, and 1 application denied. 7 non-conformings, and it will be embarrassing when this gets out. And next thing you know, we're in 1,000 feet of a school zone, and there are such things as robberies or some kind of an event happen. It's going to be embarrassing. Thank you very much for your time. I hope you do the right thing. Thank you.
Can you state your name and address, please?
I'm Eileen Skiff on Ocean Avenue in the Highlands. I'll make it quick. It's just one statement from someone else. A friend of mine went to West Marine in Woodbridge, which is right next door to the cannabis store. He said the smell in West Marine, you could get high. He said to them, "Is it always this way?" And they said 9 out of 10 times. Now, nobody was outside smoking. It was coming from inside of the cannabis store. It went right through the walls and everything. I mean, it's just something to think about. You know, you're going to be smelling it all over the town. I don't care what you say. I had to share it with everybody.
Anybody else have any statements like to make? Okay, sir. Would state your name and address, please?
Al Smuda, 215 Marina Drive. If I understand variances correctly, I think one of the objects of them is to benefit the neighborhood and town. Painting a building and taking a shed down, as people have said, is no benefit whatsoever. And on the other side of the coin, it's probably going to lead to a very detrimental effect to their quality of life. One of the things, as far as the traffic goes, nobody's mentioned, we have ferry traffic in and out of here every single business day. In the evening when the store is still going to be open, and even weekends for Yankee and Met games. So and those people that take the ferry, they take it because they want to get home faster. So they find every which way to go through the roads. If Miller Street is backed up, they'll come down Bay Avenue, go to the bridge. So traffic's going to be a problem. The parking's going to be a problem. Nobody's going to invest millions of dollars into a business for a parking lot that's going to accommodate 17 customers. It's just not going to happen. And the other thing about that is all of the surrounding towns have said no. Atlantic Highlands, I believe Fairhaven said no permanently. They put it into their governing body rules. Middletown, that's a tremendous geographical area. Rumson, probably Seabright and Monmouth Beach also. So the idea again that this business is going to be anything comparable to Chilango's Mexican restaurant, it's absurd. And I hope you're going to consider that, because it's going to be life-changing for the people that are going to be next to that business.
Anybody else from the audience? Anybody else want to add? Okay. Anybody from the board want to add anything? Okay, at that point, we're looking for a motion to either approve or deny this application. I'm sorry, yep, okay, yep.
And then he's going to sell.
Okay. Jumping the gun, sorry.
There's a question. So may I ask a question? And this is actually procedural. Just out of curiosity, it's never been clear to me. So whether this board approves or denies this application, how does the state decide which application is awarded?
Sure, I guess, well, they would need town approval to continue on their application journey.
No, I mean, if two go before the state, so if this board approves two, right?
Right.
How does the state decide? What factors do they take?
I believe it's whoever gets done first.
Yeah. Well, one's already done.
Well, they haven't gotten their final approval.
But not state approval.
Right. Well, my understanding, and if I'm wrong, please correct me, is whoever gets the state approval comes back before the town to apply for the mercantile license. Gets it.
I mean, Carolyn's not here, but I've
I
been,
think that there's a number of factors that the state considers, like operations experience, financial backing. There's a process to get a conditional approval, and they get the location approval, and they've got to go back to the state. But I don't know the exact process, but there's more that happens after the location's approved that has nothing to do with Highlands.
Mr.
It's all
Chairman?
done at the state level.
I'm sorry, I didn't mean to cut you off.
I'm sorry.
I think the applicant's attorney might be able to answer
Yeah.
that question better than anybody here.
Okay.
It's probably even beyond my depth because I didn't help the applicant with their state licensure. I believe Ms. Tierney's onto something in terms of the complexity of the factors. There may be social equity, minority ownership, women in business, all types of things the state considers. I think the important thing for this board to know is that we full well expect that if you are so inclined to approve the application, that you would do so subject to a condition that, of course, we become licensed with the state. If we don't become licensed with the state, we have no shot at the license locally and we can't open the business. So that would certainly be a standard condition, I would think, on our application and any application for retail licensure as a cannabis business.
I think there is some language about first up the bat, the first application that gets approved by the state is the one that becomes the first to us.
If it meets their criteria.
If it meets their criteria, sure.
Right. Okay, thank you. Okay.
Right.
Councilman.
I am John Anderson. I am representing Seagrass and James Whalen. I wanted to quickly thank the board for their patience. This is the 5th month running that we've been here, and we've taken up either all of your agenda or a vast majority of it over those 5 months. I just want to remind you of what we're seeking and what the legal standard is from the outset. So we are seeking a site plan approval with regard to 2 separate sites. One, the Chilongo site for use as a retail cannabis dispensary. A second, an existing surface level parking lot for use as a parking lot. With each of those 2 distinct uses, we're seeking a D3 variance. We'll review in detail during my summation the deviations from the bulk standards and the deviations from the design standards that trigger those D3 variances. There was some mention of a D4 variance for floor area ratio. I would submit to you that because that's one of the deviations on the D3, and because D3 and D4 have the same legal standard, that if you vote in favor of the D3, the D4 is kind of subsumed. Importantly, we are talking about 2 different sites, 2 different uses, both conditionally permitted in the zone. So you conditionally permit cannabis retailers, and you likewise conditionally permit principal use parking lots. And your ordinance allows a conditional use parking lot, a principal use parking lot, to serve as parking for an approved conditional use of any sort, of any variety, whether it be a cannabis retail or some other conditionally permitted use. The standard is laid out in the Coventry Square case, and you heard some testimony from our planner on it. You may be tired of me repeating it, but I think it's just absolutely critically important to your decision making. When you're evaluating a D3 variance, what my burden is and what the applicant's burden is to show that the site can accommodate any problems associated with the use, even though the proposal to the site doesn't comply with all the conditions for that particular use. And like I said, the same is true of a D4. It also tracks the Coventry standard. So what the board is charged with doing is like laser focusing its attention on these specific deviations. And the board is required to grant the variance if non-compliance with the conditions doesn't alter or affect the suitability of the location. So it's a very limited issue. It's not about whether you like cannabis or whether you don't like it, whether you think it's good for the town or whether you think it's bad for the town. Excuse me, I was very patient while everyone spoke. I just asked for the same courtesy of you tonight. And it's not about whether cannabis retailers should be allowed in this particular section of the CBD zone. They're permitted zone-wide in the CBD. We are in the CBD zone. So they are permitted on this site subject to conditions. You can't take the bait, you can't create a sub-zone or spot zone this site and say, well, it's a little different from the rest of the CBD. Maybe there's fewer businesses or more homes, and for that reason, we're not going to allow it there. That's impermissible, okay? It's not about generalized grievances with the use, and it's not about speculative fears of unsavory characters or people sleeping on the beach or whatever else we've heard. The question is whether the site is still appropriate for a conditionally permitted use despite the deviations. So let's look at 272 Bay Avenue, Chilongos, okay? It's currently a restaurant and bar. You heard it has an apartment on the second floor. It's going to be converted to the retailer. It's fully developed. It has a 2-story building. We are not expanding the building. In fact, we are scaling back the building by removing a walk-in box from the back, okay? If you were to go out there today, the building is already deficient in terms of side setback, rear setback, lot coverage, building coverage, floor area ratio, percentage of landscaping, and it doesn't even have a driveway, so there's no ability to compare the width of the driveway to any standard, okay? That's the reality today. That's how it is, right? As to each of those specific standards, we're not exacerbating any of them, not one of them, okay? At worst, we're staying unchanged. But in most cases, we're actually improving them. So you don't even require a side setback in this zone, right? 0 side setback. It's only if you have a side setback that it has to be 5 feet. That's kind of odd, but we'll go with it. We're 0.61 feet from the side of the lot, just like, basically a half a foot away. We could actually go to a 0 setback and we would become compliant. If I just had somebody come out there with some wood and some plaster, sheathing, whatever, we could decrease the setback, go right up to the lot line, and we wouldn't be talking about it. The rear setback, we got 2.1 feet now. With the removal of the walk-in box, we're going to 10.8 feet where you only require 12 feet. So we're 1.2 feet shy of the standard. The building coverage, we've already got 83%. We're taking it down to 77.6%. It's improving. The lot coverage, we're at 100%. Minor improvement, 99.7. It's de minimis, admittedly, but it's no worse. Floor area ratio, okay, you're allowed 0.65. Right now, we have 1.31. We're decreasing the floor area ratio. We're going to 1.26, okay? The driveway, we don't have one. We do the loading for a restaurant on street with big trucks. There's no loading zone. With the removal of the walk-in box, we're going to get a loading zone. 13.6 feet wide at its widest, where 15 is required, but we only take deliveries with Sprinter vans. We showed you a truck turning template. It's been unchallenged, unquestioned. Shows that the Sprinter van makes it in and out without any problem. 10% landscaping. We don't have it. We're not going to have it. There's no practical way to have it on that lot. But what we've done, we prepared a really professional landscape plan for the lot across the street, which surrounds the entire parking lot with trees, shrubs, flowers, grasses. So we're taking advantage of the land that we have across the street for the parking lot to add some landscaping and attractively appoint the street frontage. Going to Seadrift, the parking lot. It's a parking lot now, it's going to stay a parking lot. There's not going to be anything else on the lot. There's no use, right? It's just parking. You park a car there. You can't consume or purchase any kind of cannabis there. We've stipulated to that. There's not going to be any other structures on it. We're going to remove the shed. So there's no structures, no other use, just parking. The only reason that we need a variance for that lot is because 2 of our parking spaces are 6.7 feet from the rear lot line as opposed to 12. Now we could remove those 2 parking spots and we would comply and we would have 15 parking spots instead of 17. We would still have 11 more than we're required to have. But I don't think you want that. I don't think the public wants that. Everybody's been complaining that there's not enough parking in town. So we figured we'll maximize the available parking for our customers and our employees. And in doing so, we encroach slightly into a setback, okay? You've heard over many months operational testimony. You've heard architectural testimony. Our architect radically revised the plans at your request to basically rip off the front facade, completely redesign it, get rid of that pretty much eyesore type atrium that the board all expressed, I don't want to say disgust, but you strong distaste or dislike for the atrium. You heard from our engineer about the parking lot. You heard from our traffic engineer who presented ITE data. Real quick on the ITE data, as Mr. Carmona was speaking before, he talked about the ITE data as being some type of hearsay, and I just happened to look it up while we're sitting there. Rules of Evidence 803C17, exceptions to hearsay for quotations, tabulations, or other published compilations relied on by persons in particular occupations. And if you recall, Mr. Klein testified that the ITE is regularly and routinely relied on by traffic engineers such as himself. So it's not hearsay, okay? You've heard that our hours of operation are going to be limited. They're limited by your ordinance, so we're going to comply with them. That is not true of the existing bar or restaurant. Because our hours are limited, because we're not going to offer any kind of consumption, we can't offer any kind of consumption on site, presumably there's going to be less noise at night. You have people that are coming in, they're just purchasing a product and they're leaving. They're not consuming alcohol and coming out and inadvertently talking a little bit too loud or slamming a car door or getting rowdy in the neighborhood, okay? You've heard deliveries. They're going to be far less frequent. They're going to be in Sprinter vans. They're going to be done off-street instead of on-street. Heard about refuse. It's essentially office waste, not a lot of it. The product's delivered in reusable plastic totes. So they come in, they go out. They don't stack up in any kind of refuse area waiting for pickup. So we've got office waste as opposed to food scraps for a restaurant. Taking out the walk-in box, it's going to allow for a right-size spot for a Sprinter. And doing so, like I said, we reduce our building coverage, we reduce our floor area ratio, and we improve upon our rear setback. We're going to make the building ADA compliant where it's not presently ADA compliant. That's going to be true of the parking space across the street. We're going to have an ADA ramp coming back to 272. There's going to be an ADA crosswalk in between with detectable warning strips. We have 4 times the required parking for the use. The parking lot's going to be improved with significant landscaping. It's going to have bicycle racks. We're going to remove the shed. We're going to repair the dilapidated landscaping wall, and we're going to repair the signage that's there. We're going to install parking space delineation, where right now you just have a gravel lot with no delineation among spaces. There's going to be buffering in the form of brand new fencing around the parking lot. Okay. You can see the improvements that are proposed to the building itself, and in fact, you were intricately involved in designing those. Like I said, we're removing the atrium. We have an ADA ramp, new and tasteful lighting. We have molding. We're changed the proposed sign to remove the stylized cannabis leaf at your request, and now we have an anchor. Okay? We're using some muted and subdued tones as opposed to the pretty loud primary colors that you see right now. We're improving the fenestration by adding windows on the front of the building. And they're not going to be blacked out glass like the atrium. They're going to be a nice frosted glass as we introduced in our exhibits. We've added depth and interest through a standing seam metal roof supported by columns. Okay? You heard our traffic study. It was based on the IT standards, the NJDOT access code, typical in the field. Show that you have sufficient off-street parking, 17 where only 4 are required. We presented very precise calculations about the additional trips that could be expected to the site by vehicular traffic, right? I think it was 22 at peak in any 1 hour. We did the math. We showed you how many employees we would have when we have the most possible staffing. If we gave every one of those employees a stall in the lot all day long, could we still accommodate the hourly volume that we were going to expect? The numbers worked out, and we showed that we could, and we'd have room left over. We did the same exact thing with regard to building occupancy. We took peak times, we took the maximum amount of employees, we deducted those employees out from our occupancy, say how much will we have left and how long does it take to service a customer. Once again, we showed you that we could do it without queuing outside, and we promised that if we were wildly successful and there were more people, that we would do a mechanism whereby they would receive a text or some other signal that they could return to the site when the appropriate time was. We said we would put signage up so that there'd be no queuing. We have a security guard on site that would enforce that. Okay? The traffic engineer testified that the NJDOT standard for trip generation for a significant impact on traffic operations was I believe 100 additional trips. We were at 22, so we're not a significant impact on traffic. Okay? There was no contrary traffic report. The only other person that spoke about traffic was a planner, and he admitted he wasn't credentialed as an engineer, and so he did not and could not introduce a traffic report. Okay? Our use is consistent with the state statute, CREAM, they call it, legalizing the consumption of cannabis in the state. It's permitted in the zone, the entire CBD zone, not just a portion of it. You know, we're not going to pick and choose among the CBD zone. It's permitted zone-wide. It advances the goals of the master plan. And specifically, your master plan talks about aesthetic revitalization of the commercial properties, having niche retail. How much more niche can you get? You're only going to allow one of these uses in town. We certainly fit the description of a niche retailer with an aesthetic revitalization. Small-scale anchor uses to make the CBD a destination. Everybody's complaining that it's going to make it a destination, but in fact, that's what you're trying to foster and encourage on your master plan. Strengthening the commercial district by providing employment and retail services. We're a retailer, and we've said that we're going to hire locally and provide employment opportunities. Improve and develop commercial buildings, and provide adequate parking, where we're providing more than adequate parking. We're consistent with the purposes of zoning under the MLUL 4055D-2. We promote public health, safety, morals, and general welfare. We're making the building ADA compliant. We're protecting it anew from fire, and we're going to dry-proof it from flood. Our development doesn't conflict with the welfare of the municipality. We're reducing the hours, reducing noise, reducing refuse. There's no on-site consumption. We're offering a visual improvement. We're offering landscaping, etc. We're improving the visual environment. That's purpose I. Huge upgrade. It harmonizes not just with what's there, but what your aesthetic vision is for the town and for the downtown. Okay. The retail site accommodates and remains appropriate for the use. This is despite the deviations we discussed involving the various setbacks, coverages, and floor area ratio. No one over the course of 5 months, and I challenged him and I put him to the task, not one person, not the objector, not the objector's witness, not one member of the public identified any reason or any way in which this site would function even marginally better if it had a compliant side setback, if it had a compliant rear setback, if it had less coverage, if it had less lot coverage or building coverage. On the contrary, I think most people were saying the building's not too big, but it may be too small. It's not going to be big enough. So the landscaping, nobody offered any proofs as to why the site would function any better with 10% landscaping as opposed to 5 or 0. And the driveway, you saw the turning template. The truck fits. Nobody was able to call that into question with any kind of credible proofs. I don't think anybody talked about it. So we carried our burden of proof to show that the deviations, as far as those very specific setbacks, coverages, and floor area ratio, landscaping, and driveway width, could be accommodated on the site. They don't impact the ability to use the site under the Coventry case. Same with the parking. As I said, I mean, the only deviation there is the proximity of the 2 parking spaces at the rear of the lot to the adjacent home. I don't believe that homeowner was here. I don't think they complained about those 2 spots being in close proximity to their home. They're there now. We said that we would sign them for employees only so that there'd be less turnover. People would come in, they would park, the cars would stay there. There's going to be a new fence there. There's landscaping there. We had an objector. He lives and works over 200 feet away. And though he really wants to hold this application to the literal standards for a conditional use, he concedes that he never so much as inquired as to any conditions your ordinance imposes upon a law office operating out of a home. Okay? This goes to his credibility. It goes to the credibility of his lone witness, the planner. Going to the planner, he admitted that he was not credentialed in engineering or traffic engineering. Notwithstanding that, he sat here or stood here. He urged you to make up a parking requirement. You can make it up. Just do whatever you want. Make it up out of whole cloth. Don't go by your ordinance. Disregard it. Don't go by the parking standard that you went by when you approved the last application. Just make it up. Okay. He, as well as the public, are encouraging a form of spot zoning, creating some different and new criteria specific to this user and specific to this lot. That is not allowed, that is impermissible. Okay? You received, acted, and accepted ITE data on the commercial competitor's application down the road for the Grimaldi site. We presented just the same. The objector's planner said, well, you know, you can't use it. They should have to go out and pay somebody to sit at another cannabis dispensary somewhere in New Jersey for days or weeks, all day long, sit there and do traffic counts and present their findings to you. I submit to you that not only would that be cost prohibitive, not only would that be a differentiated standard for this applicant than the prior applicant, but I don't believe that it would be any more reliable. I'm sure it would be the subject of much criticism and attack if you did do something like that. The objector found the contents of your 2016 master plan unhelpful and inconvenient because we too closely mirrored the goals and aspirations. So he wanted to talk to you about how this was zoned back in 2004 when it was a residential district. That's not the case. It's a commercial district. It's the CBD. So you want to go back in time, treat it as if it's residentially zoned. You can't do that, spot zoning. Okay. I asked the planner a very simple question. Multi-part, but still simple nonetheless. How would it comply better if it had a compliant side setback, rear setback, compliant building coverage, lot coverage, floor area ratio, landscaping, or loading area? He couldn't explain it. He couldn't explain how it would comply better if it had 15 parking spots and a compliant setback on the parking lot instead of 17 and a slightly deficient setback. He never told you how any of these conditions negatively impact his client who lives over 200 feet away, or anyone for that matter. He didn't want to talk about him. Well, that's what we're here to talk about. We've talked to you about it for 5 months. That's the standard I have to prove to you in order to earn the variance. He gave up on the argument. He said that under his reading of the ordinance, these were mere bulk variants and waivers. They didn't even rise to the level of D3 variance. We, of course, applied for the D3 variance out of an abundance of caution, taking the most conservative approach, coming to you and putting on our case. So what he tried to focus on instead was the proximity of a parking lot, a principal use parking lot, to a school. Okay? You don't have a proximity restriction in your ordinance limiting where a parking lot can be in relation to a school or any other use. You can have a parking lot in the CBD zone. It's conditionally permitted. What does it have to abide in order to locate in the CBD zone? Well, it has to be used for parking by any other conditionally permitted use in the zone, such as a cannabis retailer is conditionally permitted. Check. Okay. And it can't be for commuters. This is not going to be for commuters. So we've satisfied the criteria for a principal use parking lot. In order to get to the planner's rationale that this lot is somehow accessory to the cannabis retailer, you'd have to ignore the facts, you'd have to ignore the law. You'd have to pretend that there's no Bay Avenue, no 50-foot county right-of-way separating the two lots. Somehow merge them across the street and treat it as accessory. And the reason you'd have to do that is because you very clearly in your ordinance have a single sentence that says, if you have a use on a lot, it must be considered to be principal where there are no, if there are no other principal uses or structures on the lot, then it's principal. So there are no other structures on the lot other than the parking lot. There are no other uses on the lot other than the parking lot. So therefore, it must be principal. It cannot be accessory. I'm just going to quickly circulate a section of your ordinance. We can look at it together, and it's the two pieces of your ordinance read in tandem that give us the ability to pursue these two uses separately and without having to abide the 1,000-foot proximity restriction as far as the parking lot's concerned.
Is this evidence?
No, it's from the ordinance.
Okay.
No, he's doing a summation.
It's the same thing for 5 months.
But it's not.
$5 months.
The way it works is
I'm
that an applicant,
summarizing.
when an applicant puts on a case, then there's comment, objectors, etc. At the end of the case, the applicant has the privilege of giving the last word. Sir,
Okay,
he's doing a
all right. We're trying to get to the end of this. Thank you.
Just let me know when everybody has it in front of them. All right, it looks like everybody's got it now. So the first section of your ordinance is section 21-97. We've reviewed it with you, your engineers reviewed it, Mr. Cucciaro's reviewed it, and we've discussed it at length. And it's critically important. And what it says is parking as a principal use. Parking as a principal use can be permitted in specified zones, and I'm paraphrasing, subject to the following conditions. 1, parking shall be used for permitted or approved conditional uses in the CBD zone. Just as your ordinance allows, we would be using a parking lot that's a principal use parking lot for an approved conditional use cannabis retailer. Stepping down to the second section, section 21-78, regulations. This is on accessory structures. No accessory structure or use shall be allowed on any lot in which there is not a principal structure or use. So you can't have an accessory parking lot on a standalone lot. By definition, under your ordinance, when it's on its own lot, and it's not contiguous, and it's not touching, and it's not one integrated lot, it is principal, which is allowed. But you don't have to take my word for it, because I can bring you back in time a second, if my tech expertise works. And Mr. Herman, I hope you don't mind being quoted from February. So the question came from Chief Burton as far as whether Mr. Herman agreed with our interpretation of your ordinance as far as being able to have a standalone principal use parking lot that offers parking for a separate conditional use cannabis retailer. And here's what Mr. Herman responded. The audio gets better as it goes.
If he agrees with the representation of the parking lot with regard to our zoning and ordinance, perhaps he must be requiring, yes, as a parking lot. So the parking lot. Yeah, council and I had discussed that, Mr. Cucciaro and I had discussed that as well. We felt like that was an accurate representation. And just for the record, the distance from the closest point of that parking lot to the elementary school is probably about 998 feet. So it's literally within several feet of that 1,000 foot. So even if it were to be considered, I think it would be de minimis enough to where it would be of no real relevance or consequence to the application as it stands.
And you listened to Mr. Herman, and throughout the remainder of the months, there were a number of occasions that I won't play where, in response to public comment about why it was that the parking lot could be located where it was, you said, quote unquote, that it's very clear that you can have a principal use parking lot upon which you would park cars that were visiting a use on a separate lot, a conditional cannabis retailer, that it was clear and that that there was no such proximity restriction for parking lots as opposed to retail cannabis uses. And the law hasn't changed since then, and the facts haven't changed, and those issues still remain clear. But even if that weren't the case, I'm going to come back to what Mr. Herman said. You have a parking lot, surface parking lot, that is just barely within that 1,000-foot perimeter. He said 998. We had calculations around 994. We're talking about between 2 and 6 feet to a parking lot, not to a cannabis retailer. So it's mere feet. Your ordinance doesn't say, well, how would you measure the 1,000 feet? There's nothing in there that describes that. So this is the most conservative approach you could possibly take. This is as the crow flies, a direct straight line, edge of property to edge of property, and you're still at 994 to 998 feet. And, you know, it's a little cheesy, but children aren't crows and they don't fly. You have to look at the walkable distance. The walkable distance to the nearest school, sufficiently larger. You'd have to meander down a very large hill, meander through a grid of streets to get to the site. But if you suspended your disbelief, and if we could pretend that there were a direct route, like a hypothetical tightrope between the school property and the parking lot, having traveled 1,000 feet, you'd find yourself standing in a flower bed next to a parking space. 150 feet away would be the cannabis retailer, okay? And if a child, a school-aged child, were continue to walk down the street that 150 feet, they wouldn't be allowed admittance to the cannabis retailer because you have to be 21 years of age or older to enter. They wouldn't be solicited or advertised to because it's impermissible. There's not going to be any advertising. All it's going to say is seagrass with an anchor. They wouldn't see any products because the windows are frosted glass. So having traveled well over 1,000 feet, they'd see a revitalized building with a niche retailer, with the design that you helped our architect to conceive. So I come back to the words, Mr. Herman, de minimis and of no relevance. So even if you were to somehow disregard your ordinance and disregard the fact that these lots are separate and distinct, there's nothing in the record to show that a parking lot being 1,000 feet from the school as opposed to 994 or 998 makes any difference, is any appreciable difference. So as far as the objector goes, there was a common theme. Ignore the rules when it benefits you. Don't secure approval for your law firm, but urge this board that they should spot zone the use and treat this portion of Bay Avenue differently than the rest of it. Make up a more stringent parking standard. Ignore the ITE trip generation data. Ignore those parts of the ordinance which say that the parking lot is principal use as opposed to accessory. Basically impose the conditional use standards for a cannabis retailer on a parking lot where no cannabis is being sold. Ignore the 2016 master plan. Don't treat this retailer like you did the last one. Don't focus on the legal standard of whether the site accommodates the use. Focus on the use more generally. And while many, many people said, we're not concerned with the use, that we know that the board can't touch upon the use, we know that you have to look at very technical stuff, immediately thereafter, what did they talk about? The use and the user and who would be consuming this product, and would it be people that we would want in our town? That's speculative and that's impermissible. That's not what we're here to do, and that's not the legal standard. So over the course of these 5 months, no one has provided any testimony or proofs that this site cannot accommodate the deviations. This general dislike or distaste for cannabis, or dislike or distaste for cannabis in a specific neighborhood, is not how this is to be decided. The board has to focus on whether the site can accommodate the use despite these very, very specific deviations. We've carried our burden to prove that it can, and for that reason, we're respectfully requesting that the board approve this application. Thank you.
Okay, thank you. Okay, at this point, we look for a motion to either approve or deny this application.
Motion to deny?
Is there a second?
I'll second.
Okay, I think I heard it.
Chief Burton?
No.
Mr. Kutash?
Well, I guess let's be clear with what we're doing here.
We're voting to deny.
So,
And so by saying no, you vote for the application.
so a vote yes is a vote to deny the application. A vote no is a vote not to deny the application.
Right.
Okay. The motion was to deny the application. So when the chief voted no, meaning he's voting not to deny it. He's not voting to approve it, he's voting not to deny it. So if you vote yes to the motion, you're voting to deny the application. A no vote is not to deny it. Sorry if that's bad English.
Mr. Kutash?
Yes.
Ms. LaRussa?
Yes.
Mr. Zill?
Yes.
Ms. Chang?
Yes.
Vice Chair Tierney?
Yes.
Chair Knox?
Yes.
Motion passes to deny the application.
Okay. We're gonna take a 5-minute recess and come back. We have other business to deal with tonight.
Okay.
Okay, we're back in session. Roll call, please.
Mayor Brian.
Here.
Chief Burton.
Here.
Mr. Kutaj.
Here.
Ms. LaRussa.
Here.
Mr. Montecalvo. Mr. Zill.
Here.
Ms. Chang.
Here.
Mr. Kramer.
Here.
Mr. Cody.
Here.
Dr. Peterson.
Here.
Councilmember Olszewski.
Here.
Vice Chair Tierney.
Yes, here.
Chair Knox.
Here.
We have a quorum.
Okay, thank you. Okay, brings us on to hearings on new business subdivision, LUB 2023-01, Catcherman 30 Seadrift, B76, Lot 4, 5, and 7.01. Okay, is that application here this evening?
We are, thank you. Good evening, board members and board professionals. My name is Dan O'Hearn, I represent the applicant, Catcherman LLC. I'm going to try to be brief here because I think it's pretty straightforward. My client just proposes a subdivision of 3 existing lots, as the chairman stated, 4, 5, and 7.01. They're located at 3040 Seadrift Avenue. The proposed subdivision is going to create 4 new lots. Existing lot 7.1 contains an existing single-family dwelling that will remain but will be renovated. And then the three new lots will have 3 new homes on them. The sites located in the boroughs are 2.01 single-family zone. There are several bulk variances that are required in connection with the subdivision plan under the borough ordinance. So we're just going to have 2 witnesses tonight. We're going to have the principal of the applicant, Mr. Robert Davis, and we have the project engineer, Andrew Stockton, who is a professional engineer and also will offer the professional planning testimony in support of the bulk variances. So without any further, I guess we have to swear the... I'm going to call Mr. Davis.
Bring him up.
Okay.
Do I need to turn this mic on, or?
Yeah.
Yes, if you would, please.
If you want a record to be created. Yeah. My voice is carries pretty well, but. Come up, Mr. Davis.
Mr. Davis, I'm going to swear in. Mr. Davis, please raise your right hand. Mr. Davis, do you swear or affirm that any testimony you provide before the board this evening will be the truth?
Yes.
Can you please state and spell your name for the record?
Robert Davis, RobertDavis.
Thank you very much.
Just quickly, Mr. Davis, for the record, you're the Catcherman LLC. You're a member of that LLC?
I am, yes.
Okay. Are there any other members?
My wife.
I'm going to turn this over to you, but just can you describe the existing conditions at this site?
So the existing property, there's one home that's been, someone started to raise it and renovate it after Sandy. It was a situation where the lady ran out of money. Since then, like, part of the porch is collapsing and it's really in bad shape. The rest of the property had on the one lot furthest to the left from the road, originally back I guess prior to Irene, had a big home that was tore down there. When I purchased the property, it was abandoned cars and jet skis and a bunch of stuff that we had to get taken off the lot. Now I have a couple of my job trailers that are getting ready as soon as we get some approvals to build some new homes. I've already built a couple of new homes in this neighborhood down the street on slightly narrower lots. Most of the lots across the street are 25 feet wide, a little bit narrower than what we're proposing. To answer the big question that comes up every time about parking on these lots, similar, I have a picture here I could pass around, but on the same street further down the road there where we had 25-foot lots, whenever I have these narrow lots, if we're less than 20 feet back from the road, I always carry the front of the house on the beam, push the garage door back so that I get 2 off-street parking plus the garage, because I know parking's a big issue, on these narrow streets.
Mr. O'Hearn,
as the board is passing this, can you describe what, we're going to mark that as A1, which is,
Sure.
can you at least describe?
So this is two homes that I built on that road. They're on 25-foot wide lots, and it's showing just an example of pushing the garage door back further under the house, so that, you know, right now we only have a 12-foot front yard setback, which is the same as the rest. You know, it's the same as other homes on that side of the street. There's you know, if you have 12 feet, if you try to pull in, your car sticks out on the sidewalk. You see that in a lot of homes all up and down these streets. So we, you know, spend a little bit of money. We put a big beam in the front to carry the front part of the house and push the garage door back in. It still gives you more than enough depth in your garage for a car, but it allows you two cars off street.
And just for the record, the three new homes that you propose to build.
The three new homes, yes.
Will have those features.
Correct, yes.
And what about the existing home? What about the parking for the existing home?
So the existing home is already a new foundation. We're gonna renovate it, you know, like new. You know, we're gonna really gut renovate everything, should be replaced except for what, you know, what we're required to keep. You know, it's gonna look like a new home when we're done. But that has, you know, similar to a lot of other houses on the street, it has a garage under the house, but the sidewalk is too close for off-street parking.
Other than the board, you're showing them some parking garage features. Just generally describe the other features of the new home.
So I have another example here of, I have two. So this second exhibit here is two that I've already built on this street. That we're considering, and then there are 3 stories, and then I have a 2.5 story that we're building, which we have in mind for the existing home.
All right, so just I want to show this board. This first
Yeah, that's
you said it's on the street.
Yes, these are on this same street. 2 of the homes that we've built that we're going to do something
You
similar.
Recall the addresses of those 2 homes?
5 Seadrift and 7 Seadrift.
And that's a photo you took of those homes?
It is.
Okay, and the homes you're proposing to build will look similar
Yes,
to these?
yes.
I'll just...
So, Mr. O'Hara, if you could mark that one A2?
Sure. And then you handed me another photo here, just for the record. Can you describe what that is?
So this is a 2.5 story home that we built at 3 Ocean Avenue, and this is what we have in mind for the existing, something very similar to this for the existing home that's there now.
So,
which looks like this. Is important to.
Yeah, I'll mark that as A3.
Yes, sir. Should we put this one with that?
What is this?
This is this next one is the existing home that's there now. That you can see it's in very poor shape. It's probably good.
Okay, so this will A4. This is a photo of the existing home that's on lot 7.01 now.
Yes.
Correct. One of the comments in the engineer's review letter was some testimony about where the mechanical equipment will be located on the proposed new homes. Do you know that as yet?
I do. So the mechanical equipment will be code says it has to be within 3 feet of the property line. So it'll be on the, it sticks out less than 3 feet. So it'll be on the back side of the house, but it will not encroach closer to 3 feet from the property line. That's what the building code currently is.
Do you have anything else, David?
No.
I don't have anything further for this witness unless anybody has a question.
Mr. Davis, you've been before the board, I think on a couple times. Doesn't necessarily pertain to this application, but I know you've been quite busy in this town. How many homes have you built down here since Hurricane Sandy?
So I built a couple of renovations similar to the one that's existing there, and then I built some new homes. I guess I built I've done three renovations and 7 new homes, I think.
Can you talk to us about the decks?
No, I think that's what he said. Sorry, may I ask a question? A3 is the picture of what you expect to build?
That's what I expect to build where the existing home is, that I passed a second picture around where the house is all falling down. So we're going to tear the whole roof line off of that, and basically, build it like new. The only thing, the foundation is going to remain first floor and some first floor walls that makes it a renovation. Otherwise, we would need more variances for the proximity to the property line and other things for that home.
Is there a reason why you don't have architectural plans here?
So we're waiting to see what we got approved for first. We were looking for building envelopes, basically. I brought some examples of what we have built and what we have in mind. A lot of times, many of my homes that I have built, we put plans together and we get permits, and people make a lot of changes to them. Many of them sell before I build them, and I build, do changes based on what the homeowners want. We're looking for the building envelope basically and showing the size of the homes.
Look, it's just oftentimes we're presented with architectural plans, and those architectural plans actually are a plus for you because they sort of offset the scope of the variance that you're asking for by, seeing some rather pleasing structures and things like that. So I'm just curious.
Yeah. Okay.
Well, I guess, are we looking for, this is maybe clear things up. It's a subdivision, we know that.
Yes.
Are you looking for setbacks on these homes as well? We're trying to, okay. Maybe
We are. Andrew's going to have a.
Okay, maybe we should kind of go through
to
the
show
list
the setbacks.
of variances. Okay.
Why don't we hear the testimony? So I'll just kind of interject a little bit. So it's a little unusual not to have architecturals, but there's some logic to it. He doesn't want to spend a lot of money speccing a house that he's not going to ultimately build. So the board can feel reasonably assured that if you decide to approve the subdivision, there will be a further requirement. The board could put it on them, or they can put it as a condition of the approval. That ultimately they're going to need to file plot and grading plans for individual homes that'll have to document full compliance with any relief that they're not asking for in front of this board. So in other words, if they want to build something too high, this board can't approve it because we don't see it. So the only thing that we would be acting on is, you're going to build a compliant home to be demonstrated through the zoning process and plot and grading plans. It's not something that you never see. It's more helpful for the board that you can say, hey, okay, I see the size, I see the height, I see all the dimensions. So a few of the concerns I'll just throw out there are, we've seen around town on some of the skinnier lots that we do run into issues with utility meter platforms are typically the issue, right? We saw a couple along Bay Avenue where things kind of changed through the process, and next thing you know, we got a staircase off to the side, and then they have the meter platform off to the side, and they weren't compliant with the setbacks, right? So that was sort of an issue that happened post-approval through the building department, so there's always some area for concern with that. So I think what we would want to elicit here tonight is consistency with the ordinance standards, any relief that they're asking for. So as indicated on these plans, they are asking for some nominal side yard setback variance. 6 and 8 feet are required. 6 foot on one side, 8 foot on the other, total of 14. They're asking for slightly less than that, somewhere in the 12-foot range. So they're asking for just a little bit. So if my calculations are correct, it would give them roughly a building width of about 21 feet allowed is what they're asking for tonight, whereas it would be 19 feet if they were to fully comply with the side yard setbacks, for instance. So there's a few things like that, but I'm sure their engineer will kind of walk us through specificity on that. I do have one question for Mr. Davis. In my letter, I put it in there. So you mentioned decks, but there's no specificity. You use the word decks, plural. On the front yard, any decks rising above the first floor are considered part of the principal structure and would have to comply with all the setbacks. Is your position that you are only going to have the first floor deck over the sidewalk area, parking area? Is that
correct? So the first floor deck, will have steps so that moves the front yard setback forward on that. Also, to your other point, we have 6 feet on the, or 6 or 8 feet on either side. So we're going to do a side staircase that extends back to a meter platform and goes straight down, and it's still going to give us 3 feet to pass that. So we're not going to have an issue with that. We've done that several times already. So the first floor deck, first floor of living is not part of the building envelope. And then if we do a second floor deck, I think you'll see in the picture, it steps back onto the building envelope.
So there won't be cover, it wouldn't be a covered deck.
Correct.
Gotcha.
Right, you're allowed the first floor, which would be elevated in this case because it's going to be an elevated structure for flood purposes. But a second additional deck above the first living floor deck would be where that would trigger.
Correct, yes, that would be on the building.
And again, that would be something that, we could handle through zoning. But I think it's important that we just flesh out any particular issues relating to, a slightly reduced size of the lot. And I think we'll hear a little more testimony. I just wanted to get that out there, that the two, the biggest things we see issues with are the mechanicals and the meter platforms, typically for the power meter, electric meter.
Thank you.
Andrew?
Okay, Council?
Nothing further. Any other questions?
Anybody from the board have any questions for the applicant? Okay.
Is that staircase the only way to get in the house?
No, we're going to do an interior staircase as well.
From the garage?
Yes.
So what's the distance between the staircases between the two houses? Because we've seen issues with staircases on contiguous properties within 2 feet of each other.
So we're going to have we have 6 and 8 feet on the sides. So if our staircase is, 3 to 4 feet, you still have 3 feet to get past. So that would give you, 6 feet between each property. Will still have 3 feet, a nice sidewalk width to get past their own staircase without being on the adjoining property.
And would there be any unpaved piece not in the front? Would there be any in the back?
There would be a little bit in the front on the side that does not have the staircase, and typically, it's hard to say because what the homeowner ends up picking out here, but a lot of times we do landscape pebbles and some landscaping, particularly on the side that does not have the staircase, and then what's left in the back, which Andrew's going to go over the setbacks on.
Just a quick question. So basically you're asking to add one more building lot, right? Because you have 3 and you want to make it into a 4. I just want to make sure I understand what the ask is. And with all the
Correct, yes. Yes, right now there's 3 lots. I guess at one time the 50-foot lot was when they originally created the subdivision, was 2 25s. All the lots across the street are all 25-foot widths. Andrew's going to go over a little bit how it fits into the neighborhood. It fits in really, there's a lot of 25s, there's some 34s, and then there's a few that are larger, mostly on the road behind it. But it really, kind of fits in with the neighborhood and the size homes that are there and the size lots that are there. Kind of more in the middle than the skinnier 25-foot lots across the street.
So lot 5, which is the smallest of the 3, was there a structure on it previous, or it just has always been an empty lot? Was there ever a house there, I guess is the question.
Not as long as I've been here.
Existing lot 5.
Existing lot 5, correct.
Okay. Anybody else have any other questions? Okay, carry on, please.
Our next witness is Andrew Stockton, our professional engineer and professional planner.
Mr. Stockton, do you swear or affirm that any testimony you provide before the board this evening will be the truth?
Yes, I do.
Could you please state and spell your name for the record?
My name is Andrew Stockton, Stockton.
Thank you very much.
Okay.
Do I need to qualify, Mr. Stockton? Or
Maybe for some of our newer board members.
Yeah, okay. Can you give the board the benefit of your experience and qualifications?
Okay. For those who don't know me, I'm licensed in New Jersey as a professional engineer, professional land surveyor, and professional planner. I'm also licensed as a professional engineer and land surveyor in New York and Maryland, and as a professional engineer by the state of Connecticut. I've testified for projects big and small through more than 65 or 66 different municipalities across the state, covering about half of the counties across the state as well. So have projects all over the place.
And all your New Jersey licenses are in good standing?
All my New Jersey licenses are in good, all of my licenses are in good standing.
And you're familiar with the Highlands,
Yes, I am. I'm a former member of the board.
Okay, we'll take your qualifications, thank you.
Thank you.
Mr. Stockton, I'm going to turn it over to you for your presentation.
Okay, and just for the record, it is, there are 3 existing lots on the property. It's lots 4, 5, and 7.01 in block 76. It's in the R2.01 zone. Overall, the total tract boundary is 133.33 feet wide with frontage along the westerly side of Seadrift Avenue by 70 feet deep. The R2.01 zone requires a minimum lot size dimensions of 50 feet wide by 75 feet deep. And I mentioned we only have 70 feet, and a minimum lot area of 3,750 square feet. Where with our proposal, we're going to have lots that are 33.33 feet wide by 70 feet deep, and that gives you a total lot area for each of the new building lots of 2,333 square feet. And with those dimensions, we're requesting variances for lot area, lot frontage, and we have the existing non-conforming lot depth, but that ripens into a variance for each of the new lots that we're hoping to create. There's an existing single-family dwelling on the property now. It happens to be tucked all the way towards the northern end of the property. It has an existing side yard setback of 1.6 feet, and it has an existing front yard setback of 9.3 feet. As part of our work in preparing the plan, we did measure the setbacks for all of the existing homes in the block and came up with an average requirement for the front yard setback of 12 feet. And that's what's shown on the plan as the minimum front yard setback. And it's the intent for the new buildings on the new lots to comply with that, except for, as Mr. Davis mentioned, the front yard decks, which are allowed to stick into that front yard setback area. We are meeting the minimum side yard setback requirements for the zone, the 6 feet on one side. The total of the 2 side yards, one is 6, the other is 8, and the total is 14 feet. And as proposed with the schematics that we show on the plan, we have a total 2 yard side yard setbacks of 12.3 feet. So we have a little variance request there. Our thinking is, as Mr. Herman mentioned, is it gives us a building width of about 21 feet, which is a nice size and similar product that Mr. Davis has built elsewhere in town. In addition, we're also requesting a minimum rear yard setback to more or less stay in line with the product that Mr. Davis has built. And that rear yard setback is also partially created by or impacted by the fact that we only have a 70-foot existing lot depth for in the existing condition and for each of the new building lots. The ordinance also has a requirement for providing new street trees, and we did request a waiver for planting street trees along the roadway frontage there. In looking at the neighborhood, I did prepare a lot size exhibit, and I'd like to pass that around.
A5. I'll hand that to you.
Thank you very much.
And hopefully this.
Are you going to, for the record, tell what A5 is?
Yeah, A5 is a lot size exhibit that I prepared, showing the subject property and the area surrounding the subject property or its neighborhood. The envelope that I put on there was the 200-foot radius. Knowing that we have variances, that's pretty typical what you have to notice with the public notice. And as you're looking, in that 200-foot radius, there are 47 other residential properties in the neighborhood, 19 of which are on lots that are smaller, typically 25-foot wide lots, than what we're proposing at 33.33 feet. Two lots happen to be right next door to the north, are the same exact size that we are proposing, 33.33 feet each. And then there are 11 other lots that are larger than what we're proposing, but still smaller than required in the zone. So altogether, you have about 68% of the lots in the neighborhood don't comply with the current zoning criteria. So what we're proposing is not out of character at all with how the neighborhood exists. Right?
Okay, just to, I guess, clarify that. So what you're saying is the majority of the homes in this area are 33 feet, give or take, or less?
Or less, right? And the bulk of those are actually 25 by... all of the lots on Seadrift on both sides of the roadway only have a 70-foot lot depth to them.
As we also know, too, Seadrift is a very narrow street.
Right. So
creating kind of off-site or off-street parking.
Right, and it's the ones that I shaded in green are the 25-foot wide. The ones that I shaded in the cyan color blue are the ones that are the same size, just the two right next door to our tract, and the ones that are the darker blue are larger than 33.3 feet, but still not compliant with the requirement of the zone. So what we're proposing actually fits very nicely with the rest of the neighborhood. The side yard setbacks, or the setbacks for the existing home, are just existing nonconformities that aren't impacted at all by any other subdivision of the property at all. And we have 3 existing lots, and we're creating 4, 1 for the existing home to remain, and 3 new homes to be built.
I guess it would be safe to assume, if we approve the subdivisions, and Mr. Davis built a house that was larger than what we're recommending here, or talked about here, they would come back before the board to seek variances on any kind of lot coverage or additional side yard or setbacks or such.
And exactly to that point, we did propose schematic buildings that were a little bit larger than required in the zone. So we are requesting building coverage variances for those, so that we hope to not come back to the board, that we're set up with sizes that we think will work good for the project and not have to come back to the board for future variances.
Understood.
Mr. Stockton, would you suggest that the size and types of buildings that you're proposing to build are consistent with the look and feel of the other houses on the small lots on Seadrift? Because the pictures, at least that I'm looking at, these houses appear significantly larger than the houses that are on the small lots around them, where there seem to be more setbacks, potentially farther front yard setback, plantings, a visual break between the houses. These are very close together.
Right, and there are others that I've been involved with, constructing and reconstructing after Hurricane Sandy in the neighborhood and along Seadrift and Barbary, and I agree, some of them are too close to each other, and they look like a little bit of a tower effect. But like I said, with regard to our required front yard setback for the building structures, we're meeting that for the deck. The front decks that we have, they're not subject to the setback, so they're still in line with other homes in the block and in the neighborhood there.
So we're not getting this with decks all the way out. I'm just asking you about the look and feel of the houses, since we don't have schematics.
Those homes that you're looking at there are on 25-foot lots. We're proposing lots that are 33.
I'm completely aware of what you're proposing. I'm asking, will they visually look with decks at 3 levels like this, because then you have 3 decks that need variances from the front yard setback,
No,
correct?
and we're not requesting.
We're not requesting that, no, so we're gonna have, if we have a second or third level deck, it'll be on the building envelope, so we're not requesting any, variances for decks.
So they'll be recessed.
Yes.
You actually covered that early on.
I just want to make sure, because I'm looking at
Sure.
pictures.
And I guess for some of our newer board members, if there's a covered deck, it would go into more of lot coverage. It would be considered lot coverage if the deck was actually covered.
Right.
But the way you're proposing it, you're gonna push it back, so there'll be a deck that has no cover on it, and then continue up.
And then each of the new homes will have its own 18-foot wide driveway to accommodate 2 cars off-street, as well as the garage to accommodate at least 1 additional car in the garage, too.
I don't know if anybody knows, the 25-foot lots across from Sea Drift, are they bungalows? I'm not familiar with
No.
the street, so I don't know what it looks like.
Well, there are still an awful lot of homes that need to be, lifted and rebuilt from Hurricane Sandy damage still. But a lot of the houses here have already been lifted and
You have to understand
rehabilitated.
also, really to make the house compliant, it needs to be elevated. So the homes that are not elevated, in essence, don't really comply with what FEMA put out for us. So
That's
eventually,
across the street.
Everything across the
But a lot of them
they
are.
will be lifted.
And this is,
Are there,
Yeah,
I guess
that's
the reason why I'm
yesterday.
asking
See how that-
is just trying to understand the look and feel
Can I-
of the
Right.
neighborhood
Yeah, sure.
currently.
Yeah, but I guess what I'm
So I
trying
have
to, the homes that are lifted are not compliant. They,
Most of the houses were lifted in the condition they were before Sandy, and there
Yeah.
are smaller homes that are now lifted.
yeah, there's a
So
few,
they're
sure.
compliant, but they've been lifted.
Okay.
But they're smaller look and feel.
Go ahead.
It's interesting, when we couldn't come to the first part of the meeting, so we walked every street that you could think of for a good while.
Took longer than
And I was amazed at because I don't always walk, you drive and you don't see what you do when you walk, and I was amazed at some of the larger houses that have been built, but on larger lots. And I'm wondering, why wouldn't you just go with 3 lots and build like the houses that we saw, that I'm sure could bring in the same profit in the end, rather than cramming, it is kind of cramming 4 in.
but it's not out of character with the neighborhood, exactly as my exhibit shows. It's
Again, get out of that neighborhood and go over to the other streets that run parallel. And yes, there are certainly streets that have, some of the character of that, but they also have included a different look that lifts the neighborhood rather than resembles the
I'm trying to
neighborhood.
think which houses
Just
are, I mean, I can only think of a couple that are on, the newer construction that are on larger lots. I have here actually a picture of the houses across the street you were asking about. It's actually, the picture's a little funny because it was taken today or yesterday, the air looks yellow. And I took it with my cell phone.
For the record, A6?
A6.
This is directly across the street.
From the subjects.
Yeah, you can see my sign there on the lot.
And this was taken today.
Yeah,
You can see the
those
haze.
houses were lifted. It's like, yeah, sure. It's like Jen's house.
Oh,
Like,
yeah,
they
it's
lived
yellow.
like Jen's house. Lifted.
So, I am of the opinion that the variances that we're asking for and the design waiver that we're asking for with regard to the street tree planting can certainly be granted without causing any substantial detriment to the public good and without impairing the intent or purpose of our zoning ordinance or the municipal land use law. I think as outlined or as supporting that statement, I looked at our ordinance section 21-2, that's the purpose. And I see there to promote the public health, safety, and general welfare of the municipality, taking into consideration the character of each zone and its peculiar suitability for the particular uses, and to encourage the most appropriate use of the land. And again, looking at my exhibit, what we're proposing is not out of character at all with the neighborhood. And even if you look beyond the 200-foot radius bubble that I put around the property, you still see along Washington and Barbary, many other 25-foot lots beyond what I actually counted. So I know there are a lot of smaller lots there, and that we're not proposing anything out of character. In looking specifically at the purposes under the municipal land use law, I see purposes C, E, G, and I would be the ones that I would consider being advanced by our proposal there too. I think that satisfies the positive criteria, not out of character with the neighborhood and not causing any substantial detriment to the public good. I think satisfies the negative criteria. And I think some of the variances that I mentioned specifically with regard to the existing lot depth, that would be considered a hardship for the property because there is no extra depth to be acquired to make it compliant. And then the existing non-conforming setbacks for the existing home aren't anything that's going to change. So those would be considered C1 variances for the new lot there. We went through the comments from Mr. Herman's review letter for the project, and the short answer is that we can certainly comply with all of the comments and suggestions there. Mr. Herman notes, and as I did on the plan, or on the plans, that the subject property is situated in the FEMA flood zone, AE, base flood elevation 11, just like everything else downtown. And our work in not so much in rehabbing the existing home, but in constructing the new homes, we'll have to secure permits and approvals from our floodplain manager, from the engineering department, as Mr. Herman mentioned, where we'll have individual lot grading plans prepared, and then from NJDEP for their flood hazard area permits for the project. The property is also situated in the NJDEP CAFRA zone, but this application, the scope of the work that we're proposing here, doesn't trigger any need for any CAFRA permit at all. In addition to those agencies, the project will require approval from the Monmouth County Planning Board, even though it technically looks like a minor subdivision, but because we're creating 4 lots, it's actually technically a major subdivision, so we won't have the opportunity to perfect it or record deeds with the county clerk for each lot. We'll end up recording this map by the time all is said and done.
Okay. Any other questions from any of the board members?
I have a few, Mr. Chairman. Mr. Stockton, have you discussed the number of bedrooms that are anticipated for the proposed units?
No, but I think for these size properties, it'll probably be 3-bedroom homes.
And in speaking regarding the parking standards, the
Yes.
RSIS would control up to 5 bedrooms. You'd need 3 parking spaces. I think the general testimony we heard from Mr. Davis was that his proposal would likely create 2 driveway parking spaces and one
in the garage.
And one in the garage.
At least
so
one in the garage.
A total of 3.
Right.
Which would comply with basically anything up to a 5-bedroom. Can you speak to the existing drainage condition of the roadway? I don't know if you took any elevations, or can you?
Yes, actually I do. One of the sheets in my set of drawings, sheet 2, is a preliminary grading plan based on the schematic layout. And the property is flat. Generally, the front yard, or a majority of the property, drains out from the yard area to the gutter line along Seadrift Avenue. There are certain areas of the rear yard that drain off more towards the northwest, off towards more towards recreation, place then rather than towards Seadrift Avenue. The way that I set up the proposed grading for the schematic layouts is to grade the property, even though it is flat, grade the property so that the line of the proposed building improvements forward would drain out towards Seadrift Avenue and into the existing gutter line there. And that would help reduce the impact of stormwater runoff draining onto the rear yards of other properties as it makes its way out towards Recreation Place.
And do you know the prevailing direction that the street flows once it hits the gutter line?
Generally towards the northeast, towards the waterfront. But it is flat. It is.
And is there any storm drainage available in that general area?
I'd have to kind of refer to the plan sheet to double check, but I don't think.
I mean, typically, so a couple things. This, given the small lot size, it doesn't rise to the level of a major development under the stormwater rules. Therefore, it's really not a standard to say, well, you have to comply with X, Y, and Z. As we know, we have some drainage challenges around town. So my questioning is really just to see, what's the best solution to ensure that we don't create any additional hazards or problems for the street and for the neighbors.
I don't think there are any, and my plan doesn't show any existing mid-block catch basins in Seadrift Avenue. I'm not 100% sure if there are any right there at the intersection of Recreation.
I think there's one around the corner, if I'm not mistaken. If it drains that way, I think there is one at that intersection. But
right.
The one, I'll just kind of reiterate the borough's ordinance talks about a prevailing setback, front yard setback concept. The purpose of that, so normally it's a 20-foot is the standard front yard setback, but they do have an allowance for the prevailing setback, which is basically taking an average of the, where the front facades of the other buildings are on the street within certain criteria. The representation made here today was that was approximately 12 feet, which seems consistent. And that sort of the whole idea of prevailing basically is such that you don't have a bunch of homes that are, 8 feet off the road and you put one that's 20 feet back. It just kind of really messes up the character. So in terms of the relief that the applicant is looking for, I think the width is not unreasonable for a 33-foot lot, asking for a little bit of latitude there, 21-foot wide. I do have some concerns about the depth. So the depth of the lot is only 70 feet. I get it. But as proposed, it looks like, if I did my calculations right, you'd have a 38-foot deep. Is that right? Well, I should have measured that.
12.
So if you basically have 15 and 12 is 27. Is that maybe 58? Mr. Davis, do you know how deep the houses are that you're proposing?
40. We would have, with what we're asking for, like you said, if we...
43 is what's labeled.
Yeah, 43 is the number.
I didn't see that.
For the depth, for the schematic depth that's shown on the plan.
Right. So the rear yard setback standard would be 20 feet?
Yes.
And you're asking for consideration down to just under 15, 14.8.
14.8, that's right.
And as proposed, there's going to be a deck in the back. I'm a little worried that we're using up a lot of this lot area and there's not much greenery. It's, impervious and decks and building mass. I just want to call that to the board's attention that, the relief for the rear yard, there may be some flexibility in what you are willing to do there. I think it's not egregious, but these are a lot of building on these smaller lots. So to answer Ms. Chang's commentary before, I think it was yours, about the number of lots, right? That's another planning technique is based on lot area, how many lots should you have, by strict calculation, how many are you asking for? Is the relief, is it better to have 3 lots with bigger houses, or 4 lots with smaller, maybe slightly more compressed houses? That's a planning challenge that is often faced. So the board should really consider a couple of those things. A few things that could mitigate some of that would be perhaps reducing the total depth of the house, making a little more green space. I think that's certainly within the board's purview to solicit a little more information, because as it is, that would create an additional rear yard setback variance for each home, as well as building coverage. As proposed right now, you have a building coverage allowance of 33%, and all of the homes are shown to be at just under 39%, 38% for the existing. So I think there's an ask here, certainly, but the board should weigh that and provide, their feedback and potential, concession requests if so deemed appropriate to kind of make sure that what we're getting here is appropriate. I'm always a little bit mindful of the impact of potential storm drainage. I think we're all highly sensitive to the fact that maybe we don't have the ability to ask for much based on the ordinance standards. But when you get all this impervious coverage, there will be additional stormwater that's going to be on the street. Those provide some challenges as well. I think those
Doesn't go anywhere anyway.
That's right.
2 questions I have is, was there any consideration for 3 lots instead of 4? With some just quick calculations, if you had 3 lots instead of 4, each would have 44.33, which is a lot closer to the 50 and your lot area.
There are 3 there now.
Well, I'm saying, but if you equally divided them in your subdivision, dividing up the 3, instead of having 4 of these lots, you could have 3 of the lots, and then your numbers would be a lot closer to what is required.
Well, if you also followed Mr. Herman's suggestion and we limit the depth of the building from the 43 that we show, with the size of the lot area, little changes in the building footprint become big percentages, and you end up reducing that percentage request by just a small change in the building depth.
I wasn't talking about percentages, I was talking about the actual square footage. And also the second question is, why is there so much pervious coverage?
In the zone, you're allowed up to 75% impervious coverage. And as shown on our plans, we have in the range of 47%. So we're well under the maximum permitted lot coverage for the zone.
How's that possible? Your front is driveway, then you have 43 feet of home.
Right.
You've got 15 feet in the back.
And all the side yards and
Which are gonna have a
the raised
staircase,
decks
I guess.
with stone underneath them don't count as impervious
So
coverage.
that's, I'm sorry,
Right.
I have a small
He was just answering that stone doesn't count as, counts as impervious.
It counts as pervious.
coverage.
Right. Right.
Yeah, I guess also too, the lot depth doesn't change.
Right.
So whether it's 2 houses, 5 houses, 9 houses, or 1 house, it's not going to change the lot depth. So if you have a larger home, it's just larger
I wasn't talking
impervious.
about depth, I was talking about width.
Right.
Yeah, if you have the width, you may not need to go all the way back, right? Because you have a little bit more room to play with.
I'm just
But
asking.
he could come ask for the same variances, build a bigger house, cover the same amount of ground.
That's my point. Thank you, Chief.
Be the same, be washed.
So you basically
But
would
they still
take,
need variances then.
you would take the size of one of these houses,
It
double
would,
it.
Very
it
similar
would be the
to
same,
these.
the same variance.
That's my point. Was
Same,
exactly,
right,
took the-
same.
if you made it like 3 houses, it would be basically the size of 2 houses would become 1 home. So that would take up the.
But smaller houses and have, not need variances for setbacks.
differently.
Real quick, what's the required setback, side yard setbacks, 6 and 8?
6 feet on one side, 8 feet on the other, or
And what are you
6
asking
feet
for?
one side and 14 total. 6 feet on one side and the total of 12.3.
So 2 feet. It would be a 2-foot difference. You can build a house on that bigger lot, it would only be a 2-foot difference.
And it would be a bigger
No,
house.
he wouldn't need a variance for that. That would be in compliance, 6 and 8 feet. So he's asking for 6 and whatever it
6
is.
and 6.
6 and 6. So it's 2 feet.
But the houses he would build would be in compliance, more in compliance with
Yes.
minimum lot size, with frontage, because you'd have a wider lot.
But,
So they would be.
but there would be the opportunity to build
a
bigger houses
wider
too.
house.
It would be a bigger.
So the impervious coverage probably wouldn't change from what we're
That goes
proposing.
back to the council members, I think it was the council member, they've segregated the boys over.
Not a bigger house.
That could happen, but it hasn't.
Not every house is gonna be a big house.
Right, but it might be a bigger house.
Some people
but-
like nicer yards.
Yeah, but it might uplift the neighborhood a little bit, because zoning should really reflect what we'd like to see instead of what's there already.
Yeah, well, how old are the houses that are on the 25s across the street? What year were they built? The ones that you just showed us pictures of, those little.
Yeah,
They're old
so those were built in the
bungalows.
1800s.
Yeah, they're small old bungalows that were lifted.
Okay, and they were built on 25 frontage.
Right, the whole area was divided up into 25-foot lots, and you just purchased however many 25-foot
That's a long
lots.
time
So,
ago.
right.
An interesting point.
1907, I think, was the time of the subdivision.
All right, guys, one at a time, please.
Right.
Okay.
If you were going for 3 lots, you wouldn't meet the minimum lot area. And you would still be under it.
Right.
Because the minimum is 3750, and you only have 9,333 altogether.
Right.
It's total square footage.
But you might be able to get the side yard.
But not as undersized.
Not as undersized. I mean, that would
But
look to the future instead of, well, across
Yeah.
the street. That's
Just keep
that's
building.
100%.
It's not even just across the street, it's in our block. Right next door, there are lots that are 33.33 feet wide,
And again, as I said,
and this matches that.
move off the block and look around town and look at what's happening.
But you do, and then beyond the 200-foot radius that I show on this exhibit, there are still an awful lot of 25-foot lots, an awful lot of 33-foot lots, an awful lot of 40-foot lots in the R 2.01 zone.
Houses, they've been there a long time. You're
Right.
asking us to allow 4 new, very dense houses on a very densely built lot.
Three
I'm
new
trying-
houses
Four
and one
and
rehab.
3 lots,
Right.
correct. 4 and 3 lots,
That fit.
correct. Well, they fit into what you're asking for, but they don't look like the houses that are on the street that have been there for 100 years, that are small, narrow bungalows that were lifted after Sandy, that have gardens and space between the houses and are visually separate. So that's what I'm asking. My question, going back to what Carolyn was asking, is you have a 15-foot setback on the house that, we're not seeing the design, so we're asking questions based on, wondering.
Right.
Are you building a deck off the back of the house into that 15-foot setback?
Yeah, we show schematic decks on the plan, yes.
I'm sorry, I didn't see that. Is that this?
Well, I'd like to add too, because we've had discussion with this board before.
So how far away from the rear yard line?
That would all be construction. That doesn't necessarily have a lot to do with us, right?
Unless that deck is covered.
Right, that's what's permitted.
Right. And also, it's pretty safe to assume that these existing 25 lots, whether they're an old home or not, are gonna stay 25-foot lots.
Yeah.
They're too expensive. No one's gonna go buy the next house next door at $700,000-800,000 to knock it down.
And the board's
to
worried
build a
about-
house that's compliant. It's
You know,
not
you're
gonna
worried about what's there now. Anybody that's coming in to buy those houses, they're gone.
They're gone.
They're gonna knock them down.
No
Anybody
question.
that buys those
They
houses now.
renovated them and lifted them.
Yeah, but anybody that comes in now, any young couple that comes in now, or anybody, they're gonna knock those houses down and build. And they're gonna match
Actually, we
existing
don't,
what's
we
there.
actually, we
Even
can't
if they
even say
don't buy
that.
2 lots,
Because you know what, because
they're gonna be there. You can't.
But I think
Go
that's
by what's,
speculation
you know,
though, right? We
I
are,
think also too, if someone bought those homes, if they knocked it down, they may be hesitant to do that because they may be before the board on a 25-foot lot.
They can
Yeah,
renovate
they
it.
can
up.
raise them.
They could raise that
The
house,
house up and they'll look exactly what's
put
there
new
in the
siding on it, put
neighborhood
new
now.
deck on it, it's a brand new house.
Yeah.
So much denser than what.
You're worrying about, the future is those houses are gone.
But the lot is not.
The lot is
The
not.
lot is stay 25 forever. The lot's more valuable now than
Unless
ever.
someone buys 2 lots and puts them together.
Well, then they have to come back they have to come to the board and, we
That would be a
gotta,
50-foot lot. But
Yeah.
Build something
So
that's-
I just find it
they'll
how you
build
like
something
it.
that's out of characteristic with those lots, with that neighborhood.
So I'm sorry, I can't see the measurement. How far from the back property line is the deck? Is the average deck?
No, probably half a million.
Keep
Looks
in
like
mind too
it's
that
a
it
couple
is
of
just
feet.
schematic.
400,000.
They're showing the building, the rear building facade at 14.8 feet, whereas 20 is what the ordinance setback is. And I'm guessing the deck is, I don't know, 3 or 4 feet maybe?
4 or 5 feet.
4 or 5 feet
How
schematically,
far from the property line?
4 or 5 feet from the back property line.
which it can be up to 3 per the ordinance
And
for an uncovered deck.
And then if the board imposed a lot depth
Right.
less than what we're asking, that deck area would shrink, or
Which
the
is what Mr.
space
Herman
from the
said.
deck to the lot line would increase as well.
So you might want to shrink the house.
Right, if we said, hey, you're looking at 43 feet, and the board said, how about 40? And they came to a compromise, that could satisfy a lot of that as well. Mr. Herman said that earlier. And we can make that a condition.
Could you repeat that?
Right now, they're proposing a 43-foot long house by 21 feet, I believe it is.
Right.
We could say, no, you can't build that, we want 40 feet instead of 43. It would give us, it would relieve your variance, correct? Or it'd be,
It would reduce the
it would
scope of
reduce,
the
right,
variance,
it would
right.
reduce it by a tremendous amount. Yeah, right,
They'd have to cut it by roughly 5,
right.
5.2 to be compliant.
Right, you have to cut it by 5 to be compliant, and we could ask for 3. So at that point, you're only talking about 2 feet.
So,
That's the variance we would grant if we approve that, would be 2 feet.
so we're talking about these 25-foot lots across the street. So all the new homes that have been already, they're starting to come from the other end of the road. I've done 2 of them. There's been at least 2 others done, and so people either come in and they ask for a variance for the existing building footprint, which I have done, and build brand new homes on the existing plan, or if the board does not allow it, then 2 other cases on the 25-foot lots on that side of the road, they raised the first floor and 4 walls and built, on the same existing footprint that's there. Like the chances of 2 of those, there's so many houses over there in so many various stages, like the chances of 2 of them coming up for sale, I don't think, I would be very surprised if it ever happened once over there. That's just my opinion. But,
So could you answer my question that I asked twice? Did you ever consider having 3 instead of 4?
I didn't, I kicked around all the options. So to tell you the truth, like for what I'm already trying to sell on that side of the street, 2,400 square feet compared to, I've done this all over town. Like if we were at the other end of the road, I would consider, a bigger house. But I think what I'm already planning on building there is significantly improving that part of the neighborhood, and it's going to be at a number where, I can sell. If you look at what's across the street, I have to sell a home there. I'm going to have a 50-foot lot with a 4,000 square foot home. Nobody, most of these other roads, where I did it over on Waterwich, where I did it over on Ocean, as the neighborhood builds out, hopefully it'll reach that point, where we'll sell those kind of numbers in the middle of Seadrift. But, right now, I think that this is a very nice sized new home and significantly improving the neighborhood with something we could sell.
What would the square footage likely be? What would the square footage be if you did do a bigger house on is 4,000 square feet? Is that kind of what you threw out?
Yeah. I mean, at the end of, some of the ones down by the water, are as high as 4,000 square feet. The stuff we're proposing is, 2,400 to 2,600 square feet, depending on the how much of the third floor you build out.
So what would be like the price difference in that? Where I'm going is kind of like it's kind of strange, but an affordable housing angle. Would you say you're creating more affordable housing by making it denser?
Well, I mean, no, I would not say that at all. I think that, several places all around town. I mean, I don't know how long you've been here, but I was I was one of the first, if not the first, building new construction in Highlands after Hurricane Sandy, when everyone told me I was crazy, right? And so I was the first in the 400,000s, first in the 500,000s, first in the 600,000s, first in the 700,000s, whatever. And so, like, I mean, like I said, like, hopefully, if we start, with these homes here in the high eights, which is where I plan on these homes being. If these homes were, on a different part of the street down by the water where we've already been there, where houses that I built in the eights have already resold for $1 million, we'd be talking about something else. But, right now with the rest of the street and what's already existing there, you look across the street, they're all 25-foot lots and all different, whatever, I don't think you're going to sell, million plus houses there yet. Hopefully, we keep building out these neighborhoods, and keep improving, that I think that street will reach that also.
Yeah, I guess just some communities are trying to build more densely in order to maintain affordability for some price range. But so you're saying, I mean, a 4,000 square foot house would be over $1 million. These would be under $1 million.
Correct.
So, I mean, is there any data that that 4,000 square foot houses at 50% coverage would cause any less problems with flooding or filtration than 4 houses at 2,400? Like, can that be calculated, engineer people?
It's in the FEMA flood hazard area.
Well, there's 2.
The federal government studied it, and anything that anybody does in the tidal flood hazard area, adding impervious coverage is not going to change that base flood elevation. It's not going to change the depth of the flooding at all.
I'd like to add too, from what I'm looking at, you're making the neighborhood more conducive. And to put in, 4,000 square foot homes on this block would be a bit odd. It would sound like a sore thumb. It looks like you're kind of almost going the upper end of, the middle. You got lots of 25s, you got some 35s, you got a couple that are 50. But what do you say? It was 68% of the homes there are less than 40 foot. So even if you did 3 lots, you'd be at 40 foot or 41 feet across, which is not a huge number by any difference, And I think it is important for this board to try to create neighborhoods as opposed to, okay, well, that house is too big, too small, this and that. If we can create some kind of conformity, I think that makes a better look for a neighborhood.
Right, but I think that's part of my concern is that these would be very different from what's there.
I don't know. I mean, you go towards the water, and most of the houses are like different posts.
There's more front yard setbacks, there's more backyards, there's more green space. These would be almost an entire block of impervious building and deck.
Well, I think again, it's kind of comparable to what's there.
Look at the houses next to it.
Look at the pictures though, Rob, it's not at all comparable that Carolyn can show you.
Well, the houses that we're looking at also have not raised. They've been fixed minimally since Hurricane Sandy, and they're not compliant with what the town is trying to do.
And break it up.
I would actually tend to think, if you built those houses across the street from those bungalows are going to disappear rather quickly. Because you just improved the value of that neighborhood tremendously.
Is that positive?
And then,
To get rid of,
What's that?
is it positive to just like block buildings throughout our entire neighborhoods?
Well, not only,
Consistent with the master.
I don't know if that's the right way to say get rid of the bungalows, but there's still at least one that I know of across the street that's still storm damaged and gutted, and nobody living in, similar to a lot of these other properties that we've done that with. I don't know if the goal is to get rid of the bungalows, but I think the goal is certainly to get rid of the storm damaged homes that are still vacant that, raccoons are living in.
The goal of Highlands is, the lower Highlands, is to have all elevated structures, all elevated homes, I should say.
Right. And our goal is to look at the application that's in front of us.
Correct.
And our goal is to look at the master plan, right? That's our goal, not what's it gonna sell for.
Correct.
How big is it gonna be down the road? Who's doing what, right? The positive and the negative criteria. That's our focus. Similar to the one before, the application before. We're supposed to be laser focused, not on everything else.
Sure.
On what the application is. So let's look at that.
Right, and I guess to add to that, is this application similar to what's there or different than what's there? And that to me that's really the name of the
Anything
game.
that I've seen on Seadrift, it's being built well, not same style house, you know, everybody's got their own style, but similar to what he's proposing. They're taking the old bungalows and either they're gonna renovate them and go up, or they're knocking them down. That's what the future of Seadrift is.
And we all have
Not
our, we
what
all have,
is,
sorry, go ahead.
you know,
Why do we
there
have
now,
this?
and they're building a house as big as they can on the lot. A lot of people these days don't care about the lawns, I mean, they want the house.
Well, it's true. I mean, I live in an
And I
elevated.
did it for many, many years.
Yeah. Well, I mean, it is true. I do live in an elevated house, and when you go up 12, 15 feet, your yard becomes kind of a trick to get down to.
Yeah,
You're gonna
you
put a
want
deck out
the
back, your
deck,
grill's gonna be on
You
the
want
deck.
everything up there, you're not,
Yeah, the yard becomes.
the yard is secondary.
Something that's covered by the deck. We'll get to you in a minute, man, okay?
I was just saying, but this last man standing here, I
Yes.
just, we have public portion.
We will, yeah, we're still hashing things out a little bit amongst
As
ourselves.
to this application or for just generally?
No,
For this application. Yeah, well, I guess we're getting to that.
We're also,
neighbor that stayed, they all left.
we're also doing a lot of talking, and we have a professional here who is a professional planner who's giving us his take on it.
Sure.
And we didn't let him finish, I don't think.
I'm pretty much finished right now.
I think he wants
He
to.
doesn't want to talk anymore.
Okay. All right, any other questions from the board members for the applicant? Okay.
Statement, are you allowing a statement or no?
No.
Well, hold on.
Yeah,
Okay, any other questions from the board? I see none. Okay, we'll offer questions to the public. Okay, if you can maybe go to the microphone, please, and state your name and address, please.
Hi, my name is Karen Jarmus. I live at 44 Seadrift Avenue. Where are we? Right here. And you've been talking all night about a lot of things, but yeah, our houses were built, mine was built in 1909. And somewhere along the line, people sitting where you are now had the foresight to say, no, let's go with a 50-foot minimum, we're too dense. So I have a lot of problem with, it's 3 lots, build 3 houses, they're still under the new rules. And it's a reasonable request. To go 4 houses there is beyond the pale. We already have a parking problem. We already have a flooding problem. Water comes cheerful to about here, then it comes up, and lo and behold, it stops right about here. I don't get water in front of my house now for the minor flooding. You put 4 houses there, I'm gonna be on your doorstep when I have water in mine. I'm sure they'll be nice, I have no, you know.
Okay, we're trying to keep this as more questions at this point, so if you have any questions for the applicant, that's kind of where we're at. You can make a statement afterwards, but right now we're just
I'm
asking the
done.
question.
Okay, thank you. I know you build nice stuff, I've seen it, that's great. But 3, the lots are 3, right? You have
Let's
3
kind
lots,
of get
I'm
to a
asking a
statement
question
there.
now.
I'll let it go, because we are trying to keep, I guess, our order of things. First, we do questions, so if you have any questions for the applicant?
So you have 3 lots on what we're talking about?
Correct.
And you want to put 4 houses there?
3 new homes plus an existing.
On 3, at 33 1/3 feet each, where 50 feet is the current lot size. And you're judging this on a 100-year-old, over 100-year-old lot size.
Judging it based on what's existing in the neighborhood.
But the rules have changed since then, haven't they? Okay. Thank you. I have no other questions. Good night.
Okay, thank you.
Thank you. Good night.
I would like to add, just so that, I mean, just looking at this, most of the homes don't meet the current 50-foot frontage, 100-yard deep. Actually, none of them do. Behind it, maybe it's 50, but it's probably it's got to be 70 deep.
The homes on Barbary have a 75-foot lot depth.
Right.
And
So
the
they're not-
homes on Seadrift have a 70-foot lot depth.
Right. So the whole neighborhood is not compliant.
Right.
But we have a chance to make it more compliant
Right.
with the requirements of the code, and we'd be exacerbating the existing situation. I'm not getting the reason that we would exacerbate the existing lot situation and not try to make it better and meet the requirements of the code.
I don't see it
Come
as
closer.
exacerbating. I see it as, we have 3 lots now. One of them is a 25-foot wide lot. So if you're saying that we're only entitled to 3 lots on the property, we wouldn't even be here for any subdivision review unless we wanted to adjust the width of that 25-foot wide lot. We could go and build on that today.
And then, of course, the other house that's there that you're rehabbing is on, what kind of frontage is that on?
There's one 50-foot wide lot, the empty vacant lot, and the house that's,
the current
that
house
we're
is-
rehabbing is 58 feet wide.
So you would have one non-conforming lot.
Right, but it
Instead
still
of
wouldn't,
4.
it still wouldn't change the proposed impervious coverage at all with what we're seeking to do. You would still want to build out everything that is available on the property.
But then you have to come back for a variance.
Variances.
Well, as long as we're variance free, we wouldn't have to come back.
True.
But you
But
could
will
still-
you be variance free based on what you want to do?
We'd have to study that for sure.
I guess it's important to mind too, 3 lots, 3 bigger homes.
Not
Not
necessarily.
necessarily.
Well, they could.
They could, but it's not necessary. And it would be 3 lots that is closer to what was set forth when these rules were put in place by the then land use board, looking for 50 feet in this area. Well, hey,
Well, I just kind of go by what's there. You know, I kind of always look at it, look, what do we have?
but we're
How
also
can we make it
supposed to
better?
be
I
planning
have a question
for
for
what is
Mr.
gonna happen in
Davis.
the future.
Sure, if you come up to the microphone. The houses you built at the end of Cedar, did you have to get variances for those?
I did.
Every one of them you had to get a variance.
I did.
House
yes.
of Ocean, did you have to get a variance for it?
I did not.
Do you know
I
if
think-
all the properties that Arjica built, did you have to get variances for those, for the porches, the decks, and the coverage?
Most of them, yes.
All on similar sized lots?
So the variances I've already
All
been.
over town?
Yes, so the variances I've already been granted on Seadrift were way more variances than we're requesting for these lots, for both new construction homes that I built there. Like, you know, the side yard setbacks, we were 2 and 3 feet on the side yard setbacks. We were closer in the rear, you know, to the same size home on a much smaller lot, basically. As for a lot of other homes around town. That the homes I built on, at the end of Waterwitch also were 34 feet, and we had variance there also, and a subdivision for 2 homes there as well.
Would you consider doing 3 lots of 44.33 width each?
So if I did do that, I don't know how much that would change, what I would build there. Like I said, I don't know, I'd have to really, you know, go back and think about, you know, I have to think about what I could sell there, right? I mean, it's not the nicest part of the street yet, you know? I think, you know, the more new homes we build, the nicer it gets, obviously. But I still have to sell them first before we, you know, as we get to that point, we have to build, right?
So what I'm hearing you say, though, if I could just summarize it, and if I'm wrong, please tell me, but is that you don't want to build 3 largely because they would be at a price point that would make them less saleable or
Correct.
less saleable.
Correct. I mean, if you look at all the, you know, at the end of the street, the homes are, you know, the new homes that I built, you know, we increase the prices as we've come. And then, you know, where these lots are located, you know, there's a lot of older homes. Like I said, there's at least 1, if not 2, that are still abandoned on the other side of the street. You know, so my goal is, you know, to build these neighborhoods up and increase them as we go, you know, the way I have been all along. But, you know, I don't mind stepping the bar up and making them nicer, but I still have to step it up to a point where I can sell them.
That's an economic argument.
Yes.
That basically
Yeah.
says you need 4 of those at a certain size to be able to sell them.
Correct. Yes, I feel these 4 homes are, you know, similar lot sizes and similar home sizes, just bigger, newer, nicer homes, and it'll, you know, start increasing this neighborhood.
So I have a question. So if we built 2 instead of 3, right? Like what price point do you feel is like bad? I'm not sure we should get to be talking about prices and things. That's not really.
We're talking about economics here.
Well, we shouldn't be. We shouldn't be. Yeah. Okay. But, yeah, we really should be getting to whether you sell for $1 or $1 million. That's irrelevant to the sport.
Okay. My point is that by going with 3 lots, you're more close to what the ask is on the zoning regulations. If we continuously just give people something that is drastically lower than what is the required, then we should take all of the zoning requirements and throw them out the window. That's my point.
I understand that. I just, like I said, I still think in this area, you know, this is really one of the few spots where there's adjoining lots because of a situation with it just happened to, one home, lady ran out of money, happened to be a big lot, and then there was another lot in between with that. I just think in this area, you're going to have, if you don't grant this variance, you might get two larger lots or 3 closer to the same size lots. But I think when it comes to fitting in the neighborhood, I think you're still going to end up with what you have. And so that's why I think the variance we're asking for is something not the smallest in the neighborhood, which a lot of them across the street are. We're just asking for something more in the middle.
And Mayor, I don't disagree with you, but I've said this before, with all due respect, the reason why this board exists is because you can't comply.
Yeah.
Right.
But the interesting point is, even if he was building 3, he could
Still
still
wouldn't
comply.
comply.
Still wouldn't comply, correct.
So
It would just be closer to
you're
compliance.
closer to compliance with 3 than you are with 4.
But the 4 that we propose fits the neighborhood better than 3 would, I think.
I don't think anything fits the neighborhood, and again, walking around tonight really opened my eyes. I drive the streets, but if you walk, go on Huddy, and look at that, what is it called, Eagle's Nest or something?
Yeah.
That got built there? It's like, why is that here? It seems to work. And it's encouraging other things that are being built to be a little different too.
Right, but then to some of the discussion that we've had, there really is not going to be the opportunity for a developer to come in or a builder to come in and make an assemblage of lots and create bigger lots from 2 existing homes in this area right here.
Hang on, just to build on what you just said and what Mr. Kutosh said, the odds of having 2 lots come up at the same time or in a timely fashion where someone could get both of them. Well, you got all 3. You've got a trifecta here, so that's why I'm saying you have the opportunity to, yes, you're still getting variances, but it's closer to what we're looking for. It's almost like our eye is in the past squarely, not on the future.
I just wanted to point out the Eagle's Nest house that you're talking about that Nick built was built as a renovation on top of an existing foundation, and had it been new construction, he would have needed variances as well.
And I believe the house is probably in the 4,000 square foot range. And that lot can't be more than 35 by 70. The whole house is the lot.
Done, though. All I was saying was that it's an anomaly, but it fits. Somehow it fits. It's working.
Well, that's exactly what I'm saying about this subdivision layout too. It fits how the pattern of the neighborhood exists.
But anomalies are against
But instead of 1 non-conforming minimum frontage, you want us to give you 4. So you're
No,
going
we're
from
complying
2
with
that
the
are
front,
50
we're
or
complying
above.
with the front yard setbacks. We only have the non-conforming front yard setback for the existing home.
You meant width. She's talking about lot
Minimum
width.
frontage. Wait.
Oh, the frontage.
You have 2 lots that are compliant and 1 that's not, and you want us to go to 4 that are not compliant.
And the 4 that we're proposing are not out of character at all with the neighborhood.
I think you're hearing us saying that we're not being swayed by that, at least some of us are not being.
Right, it's also what do you want versus what are you gonna get?
Correct.
So about 2 years ago, we had an applicant wanted to build 3 houses. We said no. He said, if I can't build 3, I'm not building any. He hasn't been back. He's not building them.
Yeah, lots.
Right, now it's a boarding.
Lots are still vacant.
And, well, no, the one place is like a 5-bedroom apartment building,
Yeah,
which is not the most desirable thing down there either. It's basically a boarding house,
Yeah.
where it could have been beautiful
And then,
homes.
then you're talking about building these 2 massive houses that he can build, and stuck right in the middle of that is gonna be this tiny little house.
Right.
Now, you wanna talk about something that's not gonna be characteristic to,
All I'm
Characteristic
suggesting,
to
what
the
Karen's
neighborhood.
suggesting is we
That's
have
gonna be it.
We have a code for a reason, and if we can adhere to the code, I don't understand why we would throw the code out the window.
That code doesn't fit anything in this, anywhere, basically, in this area. And that's what,
Well, I said before,
You're gonna
all
have a
of,
subcommittee to change all of this.
Yes.
it's, we should basically start saying, this is what we have. Is it realistic to say we have to have 50
We say it all
foot?
the time. We let people build on small lots all the time, or rebuild on small lots all the time. Somebody buys a 25-foot lot, we let them build that big house. Do it all the
But
time.
that's what we have
But
in
we
this
don't have to do
town.
that here.
It's not, I live on a conforming lot.
I do too.
Yeah, majority of the streets at the town is this, is 25 foot or,
In that part of town.
I mean, you're thinking about something that should never have been.
well, I think the history of it, to some degree, was once upon a time, many, many years ago, there was a movement to make bigger lots, and it didn't really happen. I mean, a few here and there, but it didn't really happen. And then all of a sudden, Hurricane Sandy hit, and I remember early and after that, there was talk from this board, oh, have you talked to your neighbor about buying the house next door to knock it down to make a conforming lot? And that didn't happen, because what happened was, the lot next door went from 200,000 to 300,000 to 400,000 to 500,000 and beyond. At that point, no one's knocking it down. No one's gonna knock it down to build a house just that's 10 feet bigger. It's just not gonna happen. You know, that's my point is,
And pay
what Bruce is
triple
saying,
the-
you gotta look
pay
at what we
double
have
taxes.
and make what we have
Yeah.
better.
Guys, are we gonna carry this over, because it's out,
Yeah,
it's almost
okay.
time.
Well, I know, we're so close to the end of this. All right, any other questions from the board?
No.
Okay, any questions from the audience? Okay, any statements from the audience?
Left the building. One's left.
Okay, so I guess just to be clear, what this is
This is a subdivision. The applicant is presenting a 4-lot subdivision, so there'll be, at the end of the day, 4 lots.
Instead of 3.
Instead of 3. One would be a renovation of an existing home with 3 new homes to be built on the 3 newly created lots. I just want the board to be careful. The application that's before you is for 4 lots.
Correct.
You can't approve something that's not what they're presenting. You can suggest to the applicant, well, we would be more amenable to approving something else, but unless the applicant consents to that, you can't vote on that, because that's not,
With revised plans.
and that's
Yes.
correct. So there's case law on this. You cannot just say, well, we want something different, we're gonna approve it.
Nope.
That's not what the applicant is presenting to you for. They seem to be sticking to that position. If they're hearing this board, if they want to propose something different, they need to propose something different. Otherwise, this is what you're being asked to vote on tonight.
And then they would have to come back before the board with new plans.
And then I think with regard to the distance between the rear deck and the rear property lines, if the board felt it necessary for us to shrink the depth of the house to make more room there, I think that's something that we would agree to. Say from 43 to 41 or 40 feet deep for the depth of the house.
Chief Burton recommended that. Okay. Any other questions? Okay, and we're looking for a motion to approve or deny this application?
I'll make a motion to approve it.
Okay, I'll second it.
Can I weigh in? I'm sorry, can I still weigh in on this?
Absolutely.
We want to, you're making a motion to approve it as is.
Approve it with the 40 feet instead of 43.
Well, then, no, that
That's
wasn't
what
the
I'm
motion.
at- that's what I'm
That's not
asking.
the motion. The motion is to approve what they presented.
What's in front, what they presented,
Now,
right.
if they are now stipulating that they will do something, they have to be clear about that.
Yeah.
Right now, he's made a suggestion. It's not a stipulation. Would you like to clarify what your proffer is?
Yeah, we would make the depth of the house 40 feet, if you think that would fit in better. Give us a little bit more rear yard setback, 3 feet more. We'll propose it that way.
Based on what he said.
On making it a 40-foot,
40-foot house.
okay, increase in the backyard rear setbacks.
Yes.
Okay, I'll still second it. Okay, roll call?
Mayor Brion.
I'm grudgingly going to say yes.
Chief Burton.
Yes.
Mr. Kutas.
Yes.
Ms. LaRussa.
Yes.
Councilmember Olszewski.
No.
Mr. Zill.
Yes.
Ms. Chang.
No.
Vice Chair Tierney.
No.
Chair Knox.
Yes.
So we have 3, 4, 5,
6 yes,
6
3 no.
yes, and 3 no's. So it carries.
Motion carries.
Carries.
Thank you.
Okay.
Congratulations.
Thank you, everybody.
Yeah, good luck. Mr. Davis, you build beautiful homes. I've seen them all over town. I have no doubt you'll do the same here.
Can we do the minutes real quick?
Okay, let's wrap this up, folks. We're already past our curfew.
We have to do the minutes and stuff, right?
Yeah. We got a couple minutes here, guys. So we're gonna continue on with our hearing real quick. Okay, communication to vouchers, April 13th, 2023 meeting minutes for approval.
I'll make a motion.
Okay.
Second, I'm sorry, that was Mr. Kutas and Ms. Chang, or Ms. LaRusso's. All in favor?
Aye. Okay, May 11th, 2023 meeting minutes.
I'll make it.
Second. Okay, same? Yep. All in favor?
Aye.
All right.
Okay, the LUB.
You can't.
Oh, no, everybody who can vote, all in favor?
Yeah.
All right.
So moved. Okay, the LUB annual report 2022.
Do we want to hear that?
That's gonna get kicked down the road. Maybe in 24 we'll do it. Yeah.
24.
Okay, so then we'll move that one down the road. Looking for a motion to adjourn.
Oh, man. Second, bye.
Good night.
Bye.
See you next month, everybody.
Chang, all in favor? Thank you. Meeting adjourned at 10:14.